Lordship, may I be permitted to mention one, my lord, filing without
all applications, please hand over this slip.
my lord,
Please,
without certified copy, my lord, I am.
just all applications, please hand over this. শোনো ম্যাডামের সাথে please hand over the slip. Yes.
One urgent applications, my lord. My lord, petitioner is the owner of that property. My lord, he constructed a house. My lord, there is a Borgadar. Borgadar filed a
This is a land tribunal.
tribunal.
Has it been heard earlier?
No,
Fresh motion.
fresh motion. My lord, your lordship kindly fix the matter on 6. Otherwise, my lord, the tribunal has given a directions upon the state government to restore the Borgadar possession. On the basis of that, BLRO takes.
What were you doing, Mr. Banerjee? It is not.
My lord, the order was passed on 22nd of December. My lord, thereafter, my lord, in the month of January, I have received the certified copy of this order. Thereafter, I have filed this application.
Give the slip.
My lord, your lordship kindly take it upon 6th of.
What is your other side?
My lord, I have given notice, my lord.
Where is the notice?
No, the notice is not there. My lord, your lordship kindly fix the date. My lord, I am served notice, and your otherwise, my lord, on 11th of March, date was fixed for restore the possession of the Borgadar. My lord, that's why, my lord, I am mentioning the
11th of March.
11th of March.
Yes.
Yes.
Yes, Mr. Mitra.
My lord, I am mentioning, my lord, a municipality matter, my lord. I understand that has been, my lord.
Assigned to us.
Yes, my lord. The other bench is not sitting.
চিঠি এসছে নাকি চিফের থেকে চিঠি এসছে তো has it already been filed?
No. Has it been?
You have filed the appeal.
No, the appeal is pending. I'll tell you, lordship, very briefly, my lord. An order was passed in a writ petition about demolition of a, my lord, portion of the property without giving any hearing to me. Admittedly, I am a party to it. Without, my lord, the order records that, my lord, I was not served. Now, my lord, I had preferred an appeal. The appeal is pending. Now, my lord, police goes and says, my lord, that the building will be demolished, my lord, on Saturday. I came to know this yesterday. My application, I have made the application ready, a small application. Since the appeal is pending.
Mr. Mitra, we do not know. No, originated determination. Is it in his lordship's list? The application?
No, I was praying for leave to file the application because, my lord, I came to know yesterday. I was praying for leave.
Your other side.
I shall give notice, my lord, because it happened yesterday.
Has the appeal appearing in his lordship's list? I'm not talking about the application.
No.
You are the appellant.
I am the appellant.
So it was earlier not heard?
No, it was not.
We don't know, Mr. Mitra, whether the file can be requisitioned because the my lord's list, had it been in the list, we could have called for the file. Anyway, you hand over the slip, give a further, I don't know whether determination has.
My lord, I am told by my advocate, my lord, the record, my lord, that the OSD of the Honorable Chief Justice has informed that, my lord, it is being assigned before this bench. The whole difficulty is, my lord, unless the matter is listed tomorrow.
Can you bring your other side at 2 p.m.? Or at 1 p.m. Please give a notice to your other side.
I shall give notice to the Howrah Municipal Corporation, easier to reach.
Who is for Howrah Municipal? You are there.
My lord.
You are there, Mr. Howrah Municipal. Any private respondent? Must be private respondent.
I have not been given the brief. Let the brief be given to me. I will take instructions, my lord. If your lordship fixes today.
The thing is, we can direct it to appear tomorrow, but we don't know tomorrow whether we would be having determination. This is the problem.
My lord,
We can
can I come back at 2 p.m., my lord? These days I find, my lord, supplementary lists are published.
we will that we can.
Oh, I know, my lord, I know, but my
You
difficulty.
file the application, we can give a direction, request the coordinate bench to fix it tomorrow so that it can be.
Very well, my lord, at least, my lord, that much if it is.
তাহলে তুমি ওই ডিটারমিনেশন যদি আমাদের কাছে এসে Mr. Mitra, still send your junior at 1:15 with a notice to others.
Very well.
Yes.
Sir, may I be permitted to
Lord.
mention
What?
Malad, the without certified copy, Malad, ma'am, of the
When was the
order was passed on 19th February. Malad, on that day, Malad, I have applied for the certified copy. Till today, Malad, I am not.
This is group 2.
Yes, ma'am.
Leave granted, yes.
My lord, may I, my lord,
Why not?
kindly to mention, my lord, item number 135 of my lord's today's list, that assigned matter, my lord.
Assigned matters,
Yes.
it will be placed on a particular date, Mr. Mitra.
Lordship.
We are shifting it, upgraded we are taking, hearing we are taking. Please keep a watch on the list.
My lord.
On a particular date, it will come at
Yes,
the
because
top.
formally my lords used to take up these assigned matters on Thursdays with my lord on the top.
We shall make appropriate steps.
Lordship.
This much, please wait for another 1 week.
My lord, my item number 2 is fixed at code number 6. It is very much
Okay,
urgent.
item number?
Item number 2 is fixed on code number 6, but lordship, I like to mention here, it is a very urgent matter. Demolition order given by the municipality will be today. I am the appellant, and since appellant met 329 by 24. Please be kind enough to give an opportunity for the conducting the hearing today.
So tomorrow it will appear. It is.
Their court is not sitting today.
If my lord does not see tomorrow, you come and tell us. Oh, kalke to.
No, my lord, here is the letter of care psychosis of the municipality that it will be demolished. I am not at all the party, owner of the property. Nevertheless, by suppressing the facts, the deed petition has been disposed of.
Matt is going to be.
I am not the owner.
Just a moment. Before the division bench, 29 तारीख. Okay. I, along with my client, failed to obtain. Who has filed the appeal?
Appeal, I am the appellant. Bolaram Dotto, I am on behalf of Bolaram Dotto. He is the appellant, but he is not the owner of the property.
Appellant in MAT 329. Who has filed?
329.
Who has filed the appeal which is in the list of his lordship?
Bolaram Dotto.
You are appearing for whom?
Bolaram Dotto.
Bolaram.
Yes. And copy has been served to everyone. Has served the copy to
So
everyone.
what is the urgency?
Urgency, municipality is going to demolish the property tomorrow. It has been given by the notice. But the problem is that falsely the case was filed by the...
This memo was issued on 23rd February. What were you doing for 1 more week?
No, I have filed the appeal. Appeal has been listed
This
today.
demolition intimation was given to you on 23rd February. What were you doing for 7 days?
I have filed, the procedure has taken. Today it has been listed. And as the matter is urgent, very much urgent, I want to have some order so that I can procure the order.
Why didn't you go and get the order from 23rd to 29th? What were you doing? Sleeping?
No, I have taken this time for filing this case.
So you have filed it earlier to 23rd February. You have taken no steps for 1 week.
The municipality has served the notice only 23rd. Naturally, I have filed the appeal on 12th February.
Yes, then why didn't you mention to the court that my appeal is pending?
No, it has not been listed. That is why I could not mention it.
You just now said that it has been listed.
It has been listed and it is in the court of 6 number number 6 quote
List.
and list number 2. Item number 2. My lord, be kind enough to give me an opportunity to go for the hearing. At what time?
এবার তোমাকে লিস্ট জানতে হবে তো, ওটা কি ওখান থেকে ফাইল আনিয়ে এখানে লিস্ট করাতে হবে?
List করাতে হবে।
কি
But
করে?
IFPR for the
List করা নেই আছে list.
writ petitioner respondent.
রিট পিটিশনার রেসপন্ডেন্ট।
But I move the writ
জন্য দিয়েছে।
আজকের জন্য শুধু আজকের জন্য
বলরাম দত্ত।
আজকের জন্য
খুলছে না মোবাইল।
Come back at 12:30
I will.
12:30, my lord.
and if you don't bring the municipality lawyer, we are not passing the order. No order we will pass. Give a notice immediately so that the advocate appears. And who is for the state?
You know who appears on behalf of Hubli Chisura municipality?
Mr. Tapos
Mr. Tapabrata, who appeared in the single bench appear
Who appeared in
nobody
the,
appeared for this party before the single bench.
so you were a party to the writ petition. You were a,
I was a party, but the question is that the appellant,
Private respondent.
yes,
সাড়ে বারোটা
the
তাও কি?
আপনি mail করেছেন না? First charge
mail কি করবো municipality?
Lordship, may I
My
permit,
lord, at least interim order.
নেবে তো বলেছে।
Lordship, may I permit that I am
Order-
mentioning the matter appear in the list to be mentioned regarding widow pension matter, my lord,
Regarding?
to be mentioned.
What was it to be mentioned?
Widow
Why
pension
to be
matter,
mentioned?
my lord,
Why to be mentioned?
my lord, widow pension matter is in
Hearing matter.
hearing matter.
So why to be mentioned? it?
We mention, my lord, fix the date.
Oh, বাবা! State করে time fix করে দিতে হবে। Give the slip,
Like two matters are there, like one
দেখে
matter.
নাও এগুলো combined list এর জন্য কেটে দিও। একটু
But-
mark করে রাখো তো। হ্যাঁ,
May be permitted to mention two matters, my lord. One matter, my lord, it is, my lord, directed to appear, my lord, in the list, but it is not appearing, my lord. I have mentioned the matter, my lord, earlier.
is it a motion?
No, it is a hearing matter. It was directed to be appear, my lord, on a particular date, my lord. But on that date, my lord, matter did not appear. Thereafter, I mentioned the matter. My lord, my mentioning was allowed, but even that, my lord, the matter is not appearing in the list. And my lord, the
Returnable date was
returnable
fixed.
date, yes, my lord.
Returnable, there was any order?
Yes, yes, yes. I have come with the order, my lord.
দেখি।
I have mentioned the matter earlier also, my lord.
So this was in the combined list.
No, my lord, it was scheduled to be appeared on 23rd of November, my lord.
এতগুলি মামলা কিসের?
My lord, I am appearing in one of the matters, my lord, in the first matter, my lord, and
What
another
did you
advocate
say?
is there, my lord.
Response that the evidence has already been called. You have used exception.
Yes, yes, my lord, everything is completed.
Then you are not the only petitioner. Who are
But-
the other
But
petitioners?
I am in the, my lord, I am the applicant, I am the, my lord, petitioner, my lord, in the first petition, my lord. I am appearing, representing the petitioner in the first petition, my lord.
So why didn't you remind earlier? It
My lord,
came
I,
on
my lord,
23rd
my lord, don't take
November.
me amiss, my lord, I mentioned the matter earlier, my lord, that was allowed, my lord. However, the matter did not appear, my lord. I mentioned the matter earlier.
চেক করে নাও তাহলে সাপ্লি তো দিয়ে দেবে।
And my lord, another matter.
জজ সাহেবের সাথে Mr. Chakraborty.
Lord, I am telling your lordship, Lord, we pray for Lord re-engagement of our Lord service into the service of the railway, Lord, pursuant to Lord one Lord railway board circular. That particular railway board circular Lord says that the engagement will be up to 30th of June 2024. So Lord, even if Lord, the petition is allowed, Lord, that it will become infractuous, Lord.
Have you written that urgency?
No, Lord, I will be supplying, Lord.
Write that urgency and hand over this.
Lord,
leave.
Lord.
আমার কাছে placed হবে সময়।
And Lord, another matter, Lord.
Not another matter, another day.
No, Lord, it will be Lord, for non-prosecution with the liberty to file before the tribunal because during the
Which
pendency,
one?
132 item, Lord, in the monthly list.
32 item.
Yes,
Who is your other side?
Lord, I will be informing, Lord. I have
Huh?
given a notice, Lord. I will be again informing, Lord.
আচ্ছা, Tuesday to be mentioned,
Tuesday.
132.
Lord. During the pendency, Lord, one speaking order has been passed. I want to challenge that before the tribunal.
132. It is an
No.
assigned matter to us.
No, Lord. 132 of the monthly list, Lord.
132 monthly list.
Monthly list.
You give a notice to be mentioned Tuesday.
Tuesday. Grateful, I am. Giving.
Other one mention, এই শোনো, এই urgency record করে যাও, my lord এর সাথে।
Lord, item number 265 of the monthly list.
Upgradation.
Lord, I am
Mention next month.
next
Lordship,
month,
with regards to item number
Next month.
141, the
Monday.
141 of your lordship's today's list. This was a part heard matter. Matter was heard by your
Yes,
lordship.
it is in the list, na?
Yes, my lord. There was a direction on 13th February 2024 that the matter would be appearing on 23rd February
Is
2000.
it in the list?
Yeah, it is in the list, and there was a liberty given to me that I could inspect the documents. That inspection is, my lord, complete.
Complete.
Yes, ma'am.
Very good. তাহলে wait for your turn. It will be shifted. One day it will come fairly at the top.
May I hand over the
My lord, on extreme
Not
urgency, my lord.
required. It is in the list.
It is in
ওই
the
assigned matter গুলো একদিনকে করে দিয়ে দেবে। Yes.
grateful.
Lord, on extreme urgency, I am mentioning a tribunal application, my lord.
But
To
motion?
seeking motion unlisted or shortlisted to be heard by my lord tomorrow. Because why I say, my lord? Why I say, my lord?
File it.
My lord,
Give the returnable date.
my lord, why I say, my lord? Monday is the date for hearing wherein my record will be, my lord, to be deleted because the notice itself says, my lord, the erroneous record to be corrected on the basis of a government order.
What did tribunal say?
Tribunal, my lord, initially on 9th of February, my lord, matter was heard and made it CAB only on the point of stay. And thereafter, I find in one date, my lord, an order matter has been appeared as forwarded. I did not notice, my lord. And order has passed rejecting my entire, my lord, original application and thereby directed to produce the record. This is the
You
order.
did not appear.
No. Matter was made CAB.
Hmm.
Matter was made CAB. Matter was not
Where
listed.
is your notice to the other side?
Well, this is fresh, my lord. This is if my lord direct,
Give the
my lord,
returnable date.
short direction for short service that so that matter can be appeared tomorrow. Because other,
Tomorrow it
my
cannot
lord, may I say, my
Tomorrow it cannot be taken up. A bench has already been fixed pertaining to an assignment.
because my lord, Monday is the date for hearing. BLR already issued notice. Monday we have received the notice.
To take appropriate steps, we need not advise.
My lord, unless my lord protects, my lord, they will deal.
It will come on Monday.
My lord, at top. Otherwise, my lord, I will be my lord,
hand over the slip. It will be in the combined list on Monday.
my lord,
Motion. Yes.
my lord, kindly see the notice issued by
On
the BLR.
Monday, it will be in the combined list as a motion. Yes, next.
My lord, on Monday 12 at 12:30 hearing has been directed to be conducted by the BLNLRO.
We are explaining something, you are not listening. Tomorrow, this bench will not be there. There will be a special bench constituted. So
In the event,
we
my
cannot take it up on Friday.
My lord, in that event, my lord, Monday at top, my lord.
Monday, you give it, it will appear.
My lord, then, my
They
lord,
mention. If it is goes down in the bottom, you mention.
my lord, then leave may be granted to
What leave? When did
short service. My lord, 48 hours.
No short service. Today we are on Thursday. Give a notice that it will appear on Monday. What short service? 48
My lord,
hours.
GP office will not accept, my lord, because
Yes,
48 hours short service not leave, my lord, only this much.
Short service is not required. Today we are on Thursday. It will appear on Monday. Give the returnable date on Monday and serve.
48, my lord, working hours is required, my lord. It is not able because Saturday and Sunday.
Was the order passed?
Order, my lord, passed on 20th February.
When did you apply for certified copy?
And my lord, the BLRO issued notice we received on Monday, last Monday, and it is from Dakshin Dinajpur, my lord, remote area, my lord. It is remote area, my lord. Everything, it was in.
লিভ দিয়ে দাও মানডে অ্যাপিয়ার করবে মানডে ওই মোশনের ইয়েতে কম্বাইন লিস্টে উপরে দিয়ে দিও
Grateful to my
Monday returnable. Yes.
May I have your lordship leave to file this appeal?
আগে মোশন তোমার কম্বাইন লিস্টে ক্যাপশন দেখো আমার কম্বাইন লিস্টে কি লেখা আছে এই শোনো জয়ন্ত But by 11:30.
Within 1 hour.
He said what we have said. If you don't give it by 11:30, we will not list the matter. Yes.
Lordship, may I permit to mention one matter, Lordship? Lordship, in the last order, Lordship, we are pleased to direct that the matter will be fixed on 20th February, but Lordship, it has not come in the list, Lordship.
20th February?
Lordship, under the heading for orders, Lordship. But Lordship, it has not come.
When was it returnable?
Lordship,
When it was made returnable? Twentieth February.
Lordship.
20.
Lordship.
Need to file supplementary. Oh, that solid school, English medium matter. Indian
Lordship.
That means you are dismissed, thereafter you remove.
Lordship.
You are for the school.
For respondent number 1, Lordship.
এটাকে দিয়ে দাও ফলো
Grateful, Lordship.
জেনে নাও লিস্টটা দিয়ে দাও জেনে নাও যে তুমি কপি করতে তাহলে
Lordship leave to file this appeal without certified copy, Lord.
when was
Judgment dated 6 February, 6 February 24. On that day, I have applied for certified copy.
the tribunal matter?
No, Lord, education matter, group 2.
What is the urgency?
Ajay, my lord, I was appearing on behalf of the respondent number 10, ex-chairman of the primary school. And my lord, his all assets has been seized until and unless I am paying rupees 5 lakhs as cost. That is the entire
bank account and assets have been seized by the.
Leave granted. Yes, yes, Mr.
With utmost hesitation, my lord, I have come up again. My lord, I thought your lordships were pleased to grant my lord leave to file the application, and my lord, with my lord an observation that it will appear before
the bench on tomorrow.
thought my lord.
Unless you give the filing number of the application, he cannot go and tell this. You ask your junior to file the application
Very
and to give the number
Lordship.
so that we can request. If tomorrow, suppose tomorrow this bench will not be there.
No, very well.
Because
Before the appropriate bench, my lord.
we will, the system is Mr. Mitra, we ask that court concerned officer that you keep the matter in
Very well. Very well.
that will be sent. Please give the number of the application by 11 by 1 o'clock.
Lordship.
Yes,
Lordship.
নাম্বারটা নিয়ে ওই কার্তিক ওটা কথা বলি। Yes,
The situation is prevailing in this.
what do you want, tell us?
I am praying for inclusion.
Inclusion of what?
Inclusion of a motion where I have prayed for.
Inclusion of a motion.
Yes, my lord.
When was the
WPSC,
returnable date? When was the returnable?
Returnable date was December. My lord, I have prayed for a mandamus for direction of appointment of a judicial officer in the State Administrative Tribunal. For the last 1.5 years, my lord, only
There
that
is no urgency. Matters are
there
pending.
is already a judgment to that effect, but
Sorry,
even
there
in
is
spite of
their
that,
judgment is a request made. Judgment is a request made.
very difficult
Yes,
situation, my lord.
yes, what you are mentioning.
মহামহিম ধর্মাবতার
Wait, keep what you are mentioning.
মহামহিম ধর্ম
My lord, I may be permitted to
When
file.
will the order pass?
My lord, 13th July, my lord, 2023, my lord, the leave
Obtain
to
the certified copy and
my lord,
file.
certified copy, my lord, it is tagged with the main file, my lord, that's why it is not available.
Tag with the main file.
Means, my lord, the one
Petition disposed of.
disposed of, thereafter, my lord, contempt petition filed, and it is tagged with the main file, my lord, that's why, my lord, certified copy is not available.
23rd July it was passed.
My lord,
Obtain this contempt matter is
appearing before the Honorable Justice Kaushik Chando, my lord, that's why, my lord, a leave may kindly be granted, my lord, to file the certificate appeal without certified copy.
Leave granted. Yes.
I'm grateful, my lord.
মহামহিম ধর্মাবতার আমি প্যারালাইসিস অ্যাপ্লিক্যান্ট ইন পার্সন মামলা করব। মহামান্য বিচারপতি সৌমেন সেন আমাকে ডাইরেকশন দিয়েছেন রেমেডি প্রেয়ার করার জন্য, সেই ডাইরেকশন কমপ্লাই করে মামলা ফাইল করেছি। অতি সংক্ষিপ্ত এই মামলাটা লিস্টে আসার জন্য এই আদেশ প্রেয়ার করছি মহামহিম ধর্মাবতার।
দিন, স্লিপটা দিন। কবে ফাইল
ইন পার্সন মামলা করব।
কবে ফাইল করেছেন?
ফাইল করেছি অক্টোবর মাসে। অক্টোবর
আপনার উকিল বাবু নেই?
আমি ইন পার্সন মামলা করব, কারণ অ্যাডভোকেটকে এনগেজ করছিলাম। তার
কে ছিল আপনার অ্যাডভোকেট?
অ্যাডভোকেট ছিলেন দেবব্রত রায়, অতরূপ ব্যানার্জি, ইয়ামিন আলী।
তো মামলা কি আগে শুনানি হয়েছিল?
হয়েছিল, হ্যাঁ, কিন্তু আমি বিচার পাইনি, সেই মহামহিম ন্যায় বিচার পাইনি, তাই বাধ্য হয়ে ইন পার্সন মামলা করব।
ডিভিশন
এবং
বেঞ্চে কি মামলা আপনার উঠেছিল? এই মামলাটা কি ডিভিশন বেঞ্চে আগে উঠেছিল?
না,
এই অর্ডারটা দাও তো।
এই অর্ডারটা দিয়েছেন মহামান্য বিচারপতি সৌমেন সেন, লাস্টে অর্ডারটা দিয়েছেন, আমাকে রেমেডি পেয়ার করার ডাইরেকশন দিয়েছেন। এই ডাইরেকশন কমপ্লাই করে মামলা ফাইল করেছি, সেটা লিস্টে আসার প্রেয়ার করছি। অতি সংক্ষিপ্ত এই মামলাটা।
এই এটাতে এইটাকে আলাদা করে মাইনরকে সম্পর্কে দেখি এক সেকেন্ড, কি পেপার বুক করতে বলে? ওর absence এ হয়ে গেছে। Appeal dismiss করে দিয়েছে। এখন সেটা against you appeal। তা আপনার মামলা তো খারিজ করে দিয়েছে, এখানে আর কি করে হবে?
আমাকে ডাইরেকশন দিয়েছেন জজ সাহেব রেমেডি প্রেয়ার করার জন্য, লাস্টে রয়েছে, লাস্টে কনক্লুশনে।
তো এই অর্ডারটা পাস হওয়ার পর আপনি কি কোনো দরখাস্ত করেছেন?
আগে
এই অর্ডারটা পাস হওয়ার পরে আপনি কোনো দরখাস্ত করেছেন?
আমি মামলা ফাইল করেছি এটার পর।
কোন কোর্টে মামলা ফাইল?
16ই অক্টোবর মামলা ফাইল করেছি।
কোথায়? সেই মামলার নম্বর কত?
ওইখানে আছে, এই মেনশন।
আরে এই মামলাটা তো খারিজ হয়ে গেছে।
হ্যাঁ, ওইটার পরিপ্রেক্ষিতে।
Can application in connection with what? এই যে ক্যান ফাইলটা করেছেন, এটা কোন মামলায় করেছেন? এই মামলায়?
এই মামলা
এই অ্যাপ্লিকেশনটা রিকুইজিশন করে নাও, করে অ্যাপ্লিকেশন হেডে দিয়ে দিও। হ্যাঁ, আপনার অপরপক্ষ কে?
এসটি মিনা। আমি আজকে কপি সার্ভিস করে দেবো, ধর্মাবতার আমাকে মেনশন অ্যালাউ করলে আমি কপি সার্ভিস করে দেবো আজকে।
কপি সার্ভিস করুন।
আর ধর্মাবতার আমি তো প্যারালাইসিস, 1 মাস 1.5 মাস পরে মামলাটা ফিক্স করার প্রার্থনা করছি। 1-1.5 মাস পরে মামলাটা ফিক্সড করার প্রার্থনা করছি। আমি প্যারালাইসিস, আমি রেগুলার আসতে পারি না হলদিয়া থেকে, ইন পার্সন মামলা করব। জজ সাহেব আমাকে লিভ গ্রান্টেড করেছেন, জাস্টিস সুব্রত তালুকদার, ইন পার্সন মামলা করার জন্য।
ওইটাকে ওই রিকুইজিশন করে নিতে পারবি? এই ক্যানটা রিকুইজিশন করে বুধবার দিনকে তাহলে দিয়ে দেবে। ওকে বলে দাও 1 মাস পরে। আপনি কবে আসবেন?
1-1.5 মাস পরে ধর্মাবতার ডেটটা ফিক্স করে দিন, 2 PM। প্যারালাইসিস অবস্থায় আসতে হয় মামলা করতে।
1-1.5 মাস পরে এই বেঞ্চই থাকবে কিনা কোনো ঠিক আছে?
তাহলে
কোথায়
এই মার্চ মাসে
আপনি পরে মেনশন করুন। আপনি যবে আসবেন তার আগে মেনশন করবেন,
কারণ
এখন মেনশন করে লিস্টে দিলে আপনি তো আসতে পারবেন না বলছেন।
1 মাস পরে 1 মাস পরে
1 মাস পরে যখন আসবেন তার 1 সপ্তাহ আগে এসে বলবেন। ওটা ফেরত দিয়ে দাও। যবে আসবেন তার 1 সপ্তাহ আগে অপর পক্ষকে নোটিশ দিয়ে অ্যাপ্লিকেশন সার্ট করে আমাদেরকে বলবেন। আমরা থাকলে আমরা শুনবো, অন্য বেঞ্চ থাকলে না। কল দি লিস্ট সকাল থেকে আর বুঝিয়ে সই খারাপ।
Item number 1, Lordship, I'm for the petitioner, Lordship. I'm praying for release on the ground, Lordship, that the impugn order, Lordship, the impugn order under challenge, Lordship, passed by your Lordship when your Lordship was sitting in the seat.
My order, you have preferred appeal again before us. Yes, I will dismiss the appeal.
Lordship, I'm praying for release, Lordship.
Lordship, dismiss the application also.
On personal ground of one of us. এরকম লেখো, the present appeal has been preferred against an order dated 9th of January 2020 passed by one of us, bracket এ আমার নাম দিয়ে দেবে, stop in view thereof, comma, the matter stands released from our list.
Lordship, let there be liberty to direction for the OSD to assign this matter
Let
before
the matter be placed before the Honorable the Chief Justice for assignment before the appropriate honorable bench. Yes, next.
নোটিশ দিও।
হ্যাঁ স্যার, একদম অবলাইজ করছি।
এই জয়ন্ত, এই যে অ্যাপ্লিকেশন সেটাকে তাহলে পড়ি, ওইটা তুমি যে আমরা বললাম মোশনটা Yes.
I am for the petitioner, my lord.
Item number 2.
2, my lord. This is my affidavit of service.
Yes. Service complete.
Lordship, I have served the respondent number 2 and 3 through speed post. They have received, my lord. I have annexed the
And what about the other respondent?
particular, my lord, with regard to the petitioner number 1. Inadvertently, I have not written in the cost title, my lord, the name of the ministry. If your lordship allow me to, I can correct the cost title, lordship.
But you have to serve them, madam.
No, my lord, they have not received. My copy is ready, but they have not received, though I have not written the name of the ministry and its address, lord.
Name of the
Ministry.
in item in respondent number 1.
1, my lord.
Leave is granted to the learned advocate on record of the appellant to make necessary correction in the cost title of the writ petition. Please the matter for further consideration 2 weeks hence. Yes. 2 weeks for the rehab. Yes,
May I please, Lord, I am for the Union of India, and Mr. Sashman Chaudhary is junior in this matter. Sashman Chaudhary is junior in this matter. Where?
Yes, Mr. Dutt.
Yes, my lord. Initially, my lord, in railways, there was steam loco, which was replaced by diesel loco, diesel engine. Now, thereafter, my lord, with the introduction of electric traction, my lord.
But you have never traveled in steam vessels?
Yes, yes.
Huh?
Yes.
Oh, no, no.
Yes.
We cannot
As-
take up the matter.
We used to
One
go
has
to,
one
I used
has
to go to Jhargram.
One has to travel
Steam
in a
loco.
steam locomotive, then cover with. Mr. Dotto, you have never. Had you been able to?
No. I traveled from Howrah to Jhargram on many occasions.
Yes. So
Now-
why there is no scope for interim order?
Yes.
Yes.
Yes, my lord, I pray. Now, what happened, my lord? Ultimately, due to after introduction of electric traction, my lord.
Is your service upon all the respondents complete? কতজনকে করেছে application?
We have served all the official respondents. One of the private respondents has received.
Complete service?
That's right.
কতজন respondents?
All official respondents.
How many applicants? You got how many now?
51 applicants.
51.
Yes. The private respondents are there. In before tribunal, there were 90. Now, before your lordship, 51.
You have no.
Only 7 private respondents.
You complete service upon them and come.
That's
কি
right.
করে নেবে?
Would we lordship have to fix it next week in the under same heading?
Mr. Dotto learned advocate.
And they never appeared before the tribunal. Private respondents.
Hardware notice. Mr. Dotto learned advocate appearing for the petitioner service. Petitioners submit that service upon all the respondents is not complete. In view thereof, please the matter for further Mr. Learned advocate enters appearance on behalf of
Union of India. All the respondents. 1 to 6. 1 to 6. 1 to 6.
What the respondent numbers 1 to 6. Stop. Please the matter for further consideration in the daily supplementary list of this court on 12th March. Stop. The petitioners are directed to complete service in the
Under the same heading, my lord.
under the same heading. Take Mr. Dotto, take back this affidavit, sir, so that.
নামটা লিখে দিই অনিরুদ্ধ বাগচি ফর সিনিয়র অ্যাডভোকেট অসীমা রায়চৌধুরী
Yes, yes, your names will be given. Don't worry. এই নাম দুজনের নাম দিয়ে item 4. Who is in 4?
My lord, in this matter, Mr. Dipendra Nayan Ray is appearing for the petitioner. He has not come to the court, my lord. I am praying for a not this week, my lord.
I am for this.
ভয়ে আসছে
Not this week.
2 weeks. Yes.
Even item number 5, Mr. Dipendra that is appearing on behalf of the appellant lordship. He is engaged in courtroom number lordship is engaged in courtroom number 18 lordship. I am praying for short passover lordship.
Passover it cannot. Not today. Yes, Mr. 6, who is in 6? The. Yes, who is in 6? Your name?
6. Well, item number 5 I am preparing. 5, item number 5.
Tomorrow. Not today we have.
Item number 6 I have. 6.
Your other, all the parties are here. Item 5.
He is for the private respondent. I have.
Which for the state?
We have served. Mr. Topon Mukherjee Landa Singh here. Mr. Topon Mukherjee Landa Singh here.
He was just now here. You were not there. Yes, item 6, who is for the petitioner?
I am the petitioner.
Petitioner?
Yes.
Yes. Have you served?
Yes,
Yes. You have served upon the private respondents?
Yes, Lordship.
Eh?
Yes, Lordship.
Take it up. Yes. Yes, tell us what is the matter.
The predecessor of the petitioner lordships was the recorded owner lordships, and after his death lordships, his 2 daughters lordships as a legal heirs, they lordship by virtue of the partition deed lordships, they settle their land amicably lordships. I have annexed the partition deed lordships. Lordship thereafter, lordships, the land has been.
What is the father's name of the petitioner?
Lordship, predecessor of the father's name was Bholanath Datta, lordship, page 20.
To the order. What order you are challenging? 6 September order.
Lordship.
You are there?
Yes, lordship.
You are there?
I am for the petition.
You are for?
Private.
Who is for the state?
4A to 4B.
So, Mr. Dhod, what is the wrong with this order?
Lord, I tell you, Lordship. Lord, kindly come to page 22 once of my petition.
22.
Page 22. That is the RSROR. This family has a property, and this family has donated a property in favor of the deity. Now, my lord, I am referring page 22. Why? Because this is a Rayati land, and my lord will find on the right hand side, my lord, Khotian number 1054, my lord, on the right hand side top. 1054, and on the, my lord, if my lord come down to the next column, 4 nong Bidhimote Rayat Dokoli Sotto Bishishto, my lord, has got it. Then on the left hand side column, my lord, Bholanath Datta on top, 142 নম্বর খণ্ড খতিয়ান হইতে খণ্ড পশ্চিমবঙ্গ জমি অধিগ্রহণ আইন অনুসারে 6-1 এবং 42 ধারা অনুসারে these are the দত্ত. So after the promulgation of West Bengal State Acquisition, retain the land, Rayati land. So now, my lord, kindly come to page 24.
950 plot number, my lord, has got it.
950.
Yes. Now, my lord, kindly come to page 25, Ija. So, what is at the first page? Same copy. Then continuation. Then 26 at page 26 is 1244, 1263. My lord has got it. 63. Then next page, my lord, Ija, again continuation. I am not referring. Now, my lord, kindly come to page 28 once. This is the deed of partition amongst the heir of Bholanath Datta, who was the Rayat in the RSROR. So, and this partition deed is about on the dated 17th August 1977, which is at page 31. Co-schedule and co-schedule, these are the partition property. Now, my lord, all these Rayati lands, my lord, will get it in co and co-schedule property. Now we are in co. Now, my lord, I have annexed the type copy of the partition deed. My lord, kindly, my lord, ignore that. Now, my lord, kindly come to page 48 straight away. On top, my lord, kindly find Sri Sri Kalimata, Sri Sri Jogadhokko, Sri Sri Shidorjiu. Now, deity's name has came into land reforms.
Yes.
My lord, at page 48 on the left hand side
is the plot.
Now, my lord, come to page, my lord, on the same page, plot number 260. On the same page, my lord, on the left hand side, page 48. My lord has got it.
Why you are showing us all these things? Tribunal has directed, go and file an application, he will decide.
Yes. My lord, my predicament is tribunal has not stated a single word about my partition suit.
Because your petition was only that you are fixing, I have made an application, BLRO has not considered it within this time, and you went before the tribunal within 7 days thereafter.
No, my lord. That is not the fact, my lord. I'll take your lordship to
Mr.
page 56.
How you are aggrieved by the order of 6 September 2020?
Yes, my lord.
We
Now
understand you have a claim.
Yes.
Now, what representation you made before the BLRO?
Kindly come to page 56 once.
Yes, 56. This is your representation.
28th, my lord, at the bottom, 28th November 2022. My lord has got it. At page 56, this was my first representation. At the bottom, my lord will get 28th November 2022.
Seal of the
My lord,
BLRO.
I have, my lord, but after copying, my lord, this seal got, my lord.
Thereafter what happened?
Thereafter, again, the second representation on 2023.
It would be good.
Well,
It would be considered.
Tribunal has not considered my previous representation, which I made on 28th November 2022.
Was your second representation made?
That is on 20th July 2023, after almost a year.
Have they received it?
Yes.
They have received it how on 20th July 2022?
That would be 2023. T is written as if even I thought it's 2022.
Now, due to non-consideration of this 20th July, you filed
Both.
an...
I went before the tribunal saying that I have made a representation on 28th November 2022, again on 20th July 2023. This was the Rayati land, but all of a sudden in land reforms.
Come to the prayer, page 20.
Yes.
Page 20. What is your prayer?
Before, my lord, I bow down, my lord. Kindly come to page 18 once.
On page 20, come. Relief short for.
Oh, to dispose of representation dated 20th July 2023. Well, it's a mistake. Now, my lord, kindly come to page 18 once.
Mr. Dhar, why you are not...
I'm not bothering. My lord, kindly come to, my lord, page 18 once.
Yes, sure.
Roman 9. I have made Roman 9, my lord, paragraph Roman 9. My lord has got it. 20th November 2022 and 20th July 22. I skipped that the 20th November in the prayer portion.
That is why it was tribunal said that he wanted to consideration of the representation of 20th July. That is right
Because
to-
in the prayer, my lord, I missed.
What can be done? Now the tribunal has directed that it was 20th July 23. You have come in quick succession on 16th August 23.
That was not the case. Already in 20th,
That may
2022, then 2020.
prove your case what has been written there. Then you should have corrected your petition. Now the application is disposed of with a direction upon the applicant to submit a demand.
Again, tribunal has directed me to file a fresh demand justice. That is one of my grievance. And
what is the problem if you file it with?
There is no problem. Then, my lord, kindly modify this order by stating, my lord, the authority should be in a time-bound manner, should dispose of my representation.
Will not make appropriate application, and you will blame the tribunal that it has not passed the order and ask the High Court that modify the order. That is why the members of the tribunal maybe they, because you are people who are appearing before the tribunal do not point out the facts.
আমি তো বলে দিচ্ছি আচ্ছা রিয়ারটাই যে
was filed.
ডিটেলস পুলিশের পার্টিশন ডিটেল কতটা বলা আছে
এই যে proposing the relief therein as disclosed in the declaration. বলে তো বলছি ফাইল সার্চ অ্যান্ড অ্যাপ্লিকেশন এটাই করতে এক্সটেন্ড করে দেয় এক্সটেন্ড করতে তারপর
being agreed by the order dated 6th September 2023, passed by the London Tribunal way number 2573 of 2023, this petition was issued by order include, the tribunal directed the applicant to submit a demand of justice addressed to the concerned PLRO, proposing the relief therein as disclosed in the representation dated 20th July 2020. From the date of getting certified copy of that order with a further direction given upon the to dispose of such representation in accordance with law in his own jurisdiction. Third submit that the plots of lands forming the basis, the subject plots of land was originally belonged to
Bholanath
predecessor in interest of the present petitioners, who, after retaining the said land during RS operation held under West Bengal State Acquisition Act 1953, acquired the right of a riot in respect of those lands. Stop. And on demise of their father, the petitioner became the absolute owner of those plot of lands, and even by executing an instrument, they made partition of those plots of lands between themselves. Stop. With utter surprise, they found that in Ella record of right, one deity has been mentioned as riot in respect of those plots of land. Stop. By making an application on 2022 28 November 2022, the petitioners requested the BLLR concerned to make necessary correction of LR record of rights, and thereafter the petitioner renewed such prayer by making a further representation dated 20th July 2023. But despite receipt of those two representations, BLR maintained deceptive silence, and hence the petitioners approached the tribunal seeking a direction upon the BLR to dispose of those petitions as expeditiously as possible. Stop. Representation. But the learned tribunal, without ignoring such fact, directed the applicants to make further representation, further demand of justice. Stop.
Mr.
Mr.
denies and disputes.
Mr.
What's your name?
Mr. Firdaus deny and dispute.
You are appearing
Such
for whom?
contention of Mr.
Respondent number 4A to 4B.
Respondent numbers 4A to 4D.
He submits that there is no infirmity in the order warranting interference of this court. Are the learned advocate peruse the materials of the court?
You are denying such contention. We have recorded that. What you are wanting?
I am not denying. He is not disputing our claim.
He also one of the.
You are not disputing.
I am
Then
one of the co-sharer. My lord, I am the owner of scheduled co-property.
He chose not to come, so that's why he's made a party in the.
who is
He's
that?
just only co-sharer. He would be benefited. He would be benefited of this order.
Who are you appearing for?
Respondent number 4A to 4D.
That
That's
is
Kali
the
Mata.
years of one of your co-sharers.
Co-sharers.
That means none has come on behalf of the state. Both acted.
He will be benefited. His client would be benefited.
Enters appearance on behalf of 4A to 4D. Affidavit of service. One appears on behalf of. বলে দেবে স্টেটে সার্ভিস করেছে কি?
Yes, yes.
Service upon the state is a BLRO is not complete.
GP কি করেছে?
BLRO service is not complete. BLRO state, where have you
State and BLR has been surplus.
Oh, you will not serve DLR.
Not DLR, not
Where?
surplus. State and BLR also surplus.
Where it is that it has been delivered. আমাদেরই চেক আপ
কপি রাখুন।
এটা ডেলিভার্ড No one appears the corona evidence such
before us. We do not find any perversity or infirmity in the hand or error or jurisdictional error to convince us to interfere with the order in stop. Consequently, the however, last time বলে দেব। However, having regard to the nature and
consequently তুমি কি করো?
Having regard to the nature and having regard to the nature of fact and circumstances of this case, we disposed of the writ petition by directing the
extending the time
to
file the demand of justice.
To submit the demand of justice as directed by the learned tribunal. Within a period of 2 weeks from date, and the BL-LRO in the event such demand of justice is submitted within the time stipulated, the BL-LRO concerned shall consider and decide such the issue contained in the said raised in the said representation upon giving opportunity of hearing to the petitioner and by passing and reason order
and
all other interested parties. All other interested parties.
Within
Stop. Such if any for the interested person, if any and such. Such exercise shall be completed.
That thing will be considered as possible at a time.
The same practical disposal for representation shall be considered as expediently as possible, preferably within a period of 8 weeks. Within a period of 8 weeks from the date of receipt of such demand notice.
Well, I'm deeply obliged. And the result of the
BL-LRO communicate his decision to the applicant within a period of 2 weeks from the date of taking such decision.
I'm deeply obliged.
Well, I am for the petitioner. This is my application for pair for conversion from Danga to Bastumal. Simple pair, I purchased this said land in the year 2020. Purchased this said land and thereafter I made several representations before the authority for consideration of the mutation and conversion of the land from Danga to Bastumal. Simple pair. I made several representations. Consider this representation, page 41, my lord. And thereafter, one notice was issued, my lord, 28 February 2023.
You did not annex the representation in your original application.
Nothing.
There was no representation. What the court will do?
No, my lord.
No representation was there. Then how can the court entertain the application?
Yes, my lord. Yes.
Kindly look at the representation alleged to have been
file, page 41. After the notice was issued at page 40 by the authority to stop construction, page 40.
অনুমোদন ব্যতীত শ্রেণী পরিবর্তন বন্ধ করিবার নির্দেশ দেওয়া হইল। নির্দেশ অমান্য করে পুনরায় তাহাতে নির্মাণ কার্য শুরু করিয়াছেন, অতএব আপনাকে জানা যাইতেছে উক্ত নির্মাণ কার্য বন্ধ রাখিয়া অর্থ নোটিশ পাইবার 60 দিনের মধ্যে অর্থ করলে আপনারা সপক্ষে নিজ নিজ কাগজপত্র
Now kindly see page 41.
I appear before the authority.
Right hand side.
24 made as 23.
Handwritten, no receipt. Not annexed to the OA before the tribunal. Nothing was annexed. Kindly look at the order under challenge.
What is the present status, Mr. Chakraborty?
My lord, today I cannot say because it has been kindly.
What
simple clear, my lord, I consider this representation.
Make a representation, then it will be considered. You have not.
My lord, I appear before the 2021. I submit the all documents.
Where is that?
I submit the all documents. Thereafter, my lord, on the 28th February 2023.
Where have you made that application, sir?
And where is the receipt?
দেখছি না তো কোথাও।
40 পরে হঠাৎ।
Now you are, it has been demolished. Anything done?
No, my lord.
Oh, ওটা দিয়ে নোটিশটা করে হাইকোর্ট। 28th February.
No, kindly come to page 40. This notice was issued in connection with
illegal conversion of land by the petitioner and directing him.
এত নোটিশ মূলে
the moment notice was given, then my lord, he approached the tribunal.
First line, what is the date? এত দ্বারা আপনাকে জানানো যাইতেছে যে গত
16th of July.
না 16/7/2021 নোটিশ মূলে।
Yes.
পরিবহন বন্ধ করিবার নির্দেশ দেওয়া হইয়াছিল। Where is that? 16 July 20.
He has not annexed.
Not annexed, my lord.
Nothing was annexed.
পরেও আপনি নির্মাণ কার্য শুরু করেছেন। উক্ত নির্মাণ কার্য বন্ধ রাখিয়া 7 দিনের মধ্যে দেখা করুন। So what is the wrong?
I appear before the authority, my lord. Kindly consider this.
But where is that application? Where is the receipt?
It was from 2021.
Yes, ma'am.
So 21, you were asked to stop everything. Page,
You are claiming himself to be the Sivait of the land in question.
Yes, ma'am.
The land was actually Danga.
Yes, ma'am.
You started construction.
Yes, ma'am.
You did not feel it necessary that I am to get it converted from Danga to Bakpur. Then on 16th July 2021, a notice was given.
Yes,
asking you to stop construction.
Yes, ma'am.
Thereafter, again on 22nd February 2023,
yes, ma'am,
they gave notice that you have not stopped it. Then you stated that I filed an application in 16 September 2021 for conversion.
No.
Now, where is that?
He is saying on 23. He is saying at page 41, 13th of February 2024, it has been overwritten as 23.
Yes. Second paragraph, he says that he made an application on 16 September 2020.
21. So
where is that?
The receipt copy, where is that?
And my lord, your lordship,
putting in such
your lordship knows there is a prescribed format.
Format, yes.
That is what has been observed as well by the tribunal. What is the wrong in the order? I fail to understand.
Adjourn this matter, my lord, next date, my lord.
No, withdraw this matter.
Oh, my lord, kindly consider or my lord, adjourn this matter. I submit, my lord, all the documents.
What document you will submit?
You have not submitted before the tribunal for the first time here.
Made an application, my lord. Prescribed form, my lord.
So why will you give you that permission? You did not file it before the tribunal. Go and file a proper application before the tribunal. What is the wrong in the order? We will interfere when there is a wrong.
No, my lord.
You comply with the order. Go and make a prescribed pro forma application. Then if they don't consider, you come.
My maid,
One A
maid
for-
application.
1A. Form 1A.
Yes, yes.
Application does not mean sending a letter to such and such. There is a prescribed form.
Yes, ma'am.
If he files, my lord, he can file. That would be decided. Or, my lord, or
File it.
if no step is taken, then you approach the tribunal again.
A dismissal shall not preclude him. In this petition, the tenability of the order dated 22nd January 2024 passed by the learned tribunal in OA number such and such is under challenge. Stop. By the order impugned, the learned tribunal dismissed the original application. Stop. Mr. Fatansa, learned advocate, appearing for the petitioner, submits that the one petitioner, the petitioner made application for conversion of the land in question from Danga to Basta since long back. But that application has not been considered, and ignoring such fact, the tribunal have erroneously dismissed the original application. Stop it. Mr. Sir. There is no receipt of the representation as annexed to the petition, which the petitioner has claimed to have filed in 2021. He submits that there was no infirmity in the order impugned, and hence there is no scope to interfere with the same. Stop. Had the learned advocate perused the materials on record? Stop. The new documents has been placed before us to demonstrate that the application was in prescribed pro forma was submitted before the concern and before the competent authority with a prayer for conversion of the land. So, even no received copy of the representation of the application dated 16 September 2021 has been placed before us. Stop. Having regard to such sequence of events, and upon considering the submission made on behalf of the parties, we do not find any perversity and or infirmity and jurisdictional error in the order impugned, which prompt us to interfere with the same. Which is sufficient to prompt us to interfere with the state. In view thereof, the original application of the petition is dismissed. So, however, this order shall not preclude the petitioner to file appropriate application in prescribed form before the competent authority. From one.
It is still there, prescribed form. Yes, yes.
Appropriate application, kindly say, my lord. Kindly say appropriate application.
application in prescribed form before the competent authority.
My lord will kindly say, my lord.
166 বলে একটা
ওয়ানের ফর্ম থেকে 4-1
করেনি কিন্তু আছে
থাকবে in the prescription will not prevent the petitioner
Preclude the petitioner to file appropriate application in prescribed form before the competent authority.
appropriate application
You will get in manual, not in land reforms act. Land reforms I am having. It's not required, my lord. Kindly say appropriate application.
Prescribed form কেটে দিচ্ছি।
দেখি দেখো ওখানে আছে ওই বান্ডিলটা আরে
prescribed pro forma is there, I think. Form of prescribed pro forma
আচ্ছা ইয়ে আছে আমার ম্যানুয়ালটা ছিল না
ম্যানুয়ালটা বের করো পেয়ে
my lord, it would have sorted, my lord, if your lordships say appropriate application, not in the prescribed form, appropriate application.
No, again it will be rejected then. If we file appropriate, he will go and file one application. Then it will be rejected, not in form. Again tribunal, again high court.
Tribunal has said that appropriate format it has not been made.
Prescribed pro forma. You know prescribed pro forma is there.
No.
ওই দেখো ও জানে
1A most probably where is rule there is rule rule আছে Land reforms rules
My lords are having manual.
yes manual there is in the manual there manual of 1991 is with us but rule it will remain in rule
ওই যে মোটা বইটা আছে দাও ল্যান্ডের মোটা বইটা দাও ওই যে পেছনে আছে
হ্যাঁ
ঝালিয়ে নেওয়া দেখে নিলে ঝালিয়ে নেওয়া
My lord has not, my lord kindly come to page 47. My lord, it is there.
Appropriate application in prescribed pro forma বলেছো তাই বলেছো
হ্যাঁ there is rule
got it
I have got also.
file it in prescribed pro forma
there is a prescribed pro forma 1A you should have
appropriate application in the prescribed pro forma before the competent
authority
application disposed no dismissed that's it
এই নিন কোর্টের বইটা নিন
applicationটা dismissed paragraph
আমার হয়ে যাবে নইলে বইটা একসিট তো দেখে নিবি লোকের লাল ব্রিকটা নিচ্ছি
কবে বলছো
deeply obliged, my lord.
That's all.
yes your ma'am
Yeah, that's all.
writ petition dismissed however this
On
order
a discharge, non-dismissed, my lord. So, kindly consider this severe, my lord.
this order will not preclude you to file application in prescribed pro forma go file it
বার অন্য কিছু নেই তো
okay
yes where is ডাকো ওই ডাকো ওই ফিক্সটা ডাকো একবার we have been assigned a different determination by because one court is not sitting we will take it up on 6th at 12 noon any problem
6th
yes 6th is a Wednesday we can fix the time subject to what you say
because Mr. Banerjee is not here, my lord. May I call him up, my lord?
let it be on 6th
My lord.
let it be there on 6th if any problem is faced by you come and
We'll only take, my lord, a very little time because we'll only show what is the scope of remand.
we understand that we have fixed the matter from another bench so we cannot once we start hearing you we cannot we will
My lord,
not stop
my lord.
you to finish it
I'll follow.
ছ তারিখ বলছো? 6 তারিখ 12টার সময় বলছো। On 6th it will be 6th হচ্ছে বুধবার তো, তাই করে দিই। হ্যাঁ 6th at 12. Or you come and tell us after 5 minutes.
That will be better, my lord. This is lordship allows. No, I'm
Mr.
coming.
Banerjee, let your junior be here.
No, I am here. For this matter, I
So
will.
come immediately.
My lord.
Yes, next.
Item number 8, my lord, I am for the petitioner.
Hmm.
Service upon private respondent has not been confirmed yet. Kindly fix on
Yes.
next week. Fix on date.
2 weeks complete service. Yes.
1 week, my lord. 1 week.
Abar 51.
Lordship, on behalf of School Service Commission, respondent Mr. Konokiran Bandyopadhyay is appearing, my lord. He is on his legs, my lord.
45. What happened?
My lord, last occasion, my lord, your lordship directed me to file a fresh service upon the school. My lord, since the school has not appeared, even service, my lord, this is my service, my lord, school has duly served.
Tell us what is the matter.
Matter is, my lord, this is a matter of general transfer on special ground on my child's and wife's medical ground.
Who is the state respondent?
State respondent duly appeared, my lord. Last occasion, your lordships, kindly see the order.
They appeared?
Yes, yes, yes. All parties are, apart from the school, all parties are appeared.
Vivek Jyoti Basu.
Yes, yes. My lord, latest, since my learned friend is seeking time, my lord, I am not seeking any ex parte order. Let it be adjourned. Only not today, making not today.
Yes, not today.
Not today.
Good.
না বলো নট টুডে না, এটা কি অন্য কোনো ইয়েতে রাখতে পারি? লিস্টের জ্যাম হয়ে থাকছে না? তাহলে লিস্টে থাকবে না? তোমার মনে থাকবে? The next Thursday. Yes. All right. ওটা ওই যে 12টায় যেটা ফিক্সড আছে, 6 তারিখ 12টা। Yes, next.
Time for the
Same.
My lord, my application is pending. My application is pending before the school authority. My lord, I am a divorcee lady. I have applied after my dissolution of marriage.
Come on Thursday.
Lordship.
Thursday.
School served. My lord, similar prayer since
My lord, I'm led by Mr. Shamimul Bari for the state.
my lord, this is my service.
Where is he?
My lord, he is in court number 18. My lord, he's on his
All these 3 matters are done. Next.
deeply obliged.
49.
My lord, I am for the petitioner. Mr. Dilip Kumar Sadhu is an advocate on record, has gone out of the court. He's due to his mother's illness. Due to his mother seriously ill. So I pray for not this week.
Next Thursday করে দাও।
My lord, item number
49 দেখি ফাইলটা।
My lord, I'm informed Mr. Ujjwal Rai is on his way for the petitioner, my lord, praying for a short passover.
Next Thursday করে দাও। কেন ফলো করতে হবে? খুব ফলো করতে হবে।
I'm for the state, my lord. Led by Jayanta Samanto.
It was hard earlier.
No, my lord.
2 weeks করে দেবে, মানে Thursday week করে দেবে। Yes.
Also, same.
My lord, I am for the petitioner in this matter.
Where is the Advocate General?
My lord. My lord, even the Mr. Supratim Laha, your lordship recalls, my lord. Nor he was also there, my lord.
Not today করে টপে রেখে দিও ওটা।
My lord. So deeply obliged, my lord.
সেদিনকে আসুক না হয় yes
My lord, tomorrow it will retain its position at the top, my lord.
tomorrow it cannot be taken up tomorrow this bench will
My
not
lord,
be
my
sitting whenever we take up this supplement
Again, my lord, it will be at the
it will retain its position yes next
my lord.
yes দেখি ভাই একটা ফাইল দাও ঝট করে দাও মামলা ডিসপ্লে জন্য No one appears on behalf of the petitioner and no accommodation has been sought for. Please be met at 3 weeks.
My lord, praying for
Item number 53.
You wait for the petitioner. You wait for the petitioner in 52.
no, my lord.
52 file type second of supplement file ID করে ঠিক আছে
Item number 53.
53 একটা ফাইল দাও কি অর্ডার হয়ে গেছে Oh. No one appears on behalf of the petitioners and no accommodation has been sought for. Please the matter 3 weeks since.
53. The Lordship 53. I'm here on behalf of the petitioner.
Which one?
53. The Lordship praying for not today.
তাহলে অর্ডারটা দিও না ওটা 53টা 3 weeks since করে দিও yes অর্ডার দিতে হবে 54
Item number 54.
দেখুন ওকে সেটাও 3 weeks করে দাও
Item number 55.
You are there, Mr. Chakkur. You are there, Mr.
55. 55, my lord. Your lordship, if remember.
The tribunal not sitting.
Tribunal not sitting, and my lord, there is a development. On 20th, I wanted so that the matter is not reached by your lordship before 20th. On 20th, the matter was taken up, and 12/2024 is the next date. 12/24. This year, 12 December.
But it will be heard by a single bench there.
No, division bench.
What is the dispute?
My lord, the dispute is the petitioner applied for the post of clinical tutor come demonstrator. Isn't it post for
Applied for the post of
clinical tutor demonstrator? Say it is by common parlance, this is lecturer stage of the dental education. As we have lecturer, this is this. Now, the petitioner acted as teacher also. There was a scope of allotting 2 marks each year. And we not
what do you
dental.
want, Mr. Bandyopadhyay?
My lord,
what do you want from us?
my lord, I want your lordship to be heard because this is a complete failure of justice.
But how
These matters can never be heard within 2-3 years, my lord.
you
Then
make
extreme suffering.
No,
We
doctor.
have no scope where to go.
No,
There is a legal expression, quo vadis, where to go.
You file a preponement application there and come, Dr. Bandyopadhyay. Because that is we were placed an order of a coordinate bench saying
My
that
lord,
go and file a
what is the order, your lordship says? The bench, Honorable High Court expects that the matter will be heard on the next day. I argued the same thing before Justice Tandon. Justice Tandon was of the view that since there is a mandamus.
Justice Tandon has passed an order.
What is the order, my lord? The order has completely failed.
No, preponement of the application before the tribunal.
The matter was placed before the
Isn't
tribunal.
it-
The tribunal is sitting single bench. I cannot invite my lord to see the tribunal. Nothing is being done in tribunal. My lord, as an advocate, what should I do?
Dr.
My
Bandyopadhyay,
lord.
file an application for preponement there. If it is dismissed, you come.
Then, my lord,
Consider this.
No. I shall abide by whatever falls from my lord. I have to. I am desperate to be heard by your so that the matter is heard. My lord, I am not afraid. We have very good points. We have very, very convincing points. It will take 10 minutes.
No, but we are not in a position to consider the same.
My lord,
Since the matter is pending.
my lord, I have to. Then, my lord, I have a prayer.
Then, Dr. Bandyopadhyay, you kindly place before us that order you have obtained.
Yes, my lord. এই মধ্যে আছে 20 তারিখের অর্ডার।
There was any scope of interim order in your application, Dr. Bandyopadhyay?
My lord, there was when
there was any scope for interim order?
No, there was no scope for interim order. There was a scope of keeping up a post vacant for me. So when I filed that application, when I moved that application, there was a nice development. The state came with a document.
We keep it next week. You come with a short supplementary affidavit annexing the earlier order and what the state has come for, what they placed before the tribunal. You are just now saying state came forward and said?
No. It was during the motion stage.
Motion stage, your interim order was refused?
No, my interim order was not refused. I stated before you. When I pressed for the interim order, let one post be vacant for me. State came with an order of transfer of 5 persons, transfer order of 5 persons, showing that by those persons the vacancy has been filled up, which was a fraud. But my lord, the Honorable Tribunal directed me to oppose that. I opposed that. That is also on record. That is also on record.
What happened? What order was passed?
No order was passed. Order for exchange of affidavits on the basis of that. I did that.
Interim application.
In the interim application, no order was passed.
That is also pending.
That is also pending.
That is a MA.
MA. The MA and the matter will be heard.
My lord, file an application for preponement of the date and then come to us by filing supplementary affidavit, we shall.
Then these matters shall be pending before your lordship.
How we can keep it pending, doctor?
Oh.
Correct. Correct.
Actually, my lord, there is a single bench in the tribunal. The tribunal shall not hear that application. It will give 2 days, as the trial court does. Your
Has there
lordship.
been any development, Mr. Mukherjee?
Kindly excuse me, I cannot place it before my land fund. It's a confidential document.
This, my lord,
Kindly see the second.
this is to be learned. How and development of tribunal could be.
Some development has taken place. এখন তো বিয়ের আগে পড়ে দিলে ইয়ে হবে না তো হেমন্তর পাবি না তো ওকে ভাঙিয়ে দেবে
31শে জানুয়ারি, তাই তো? Meeting convened. Any meeting convened thereafter?
Again, meeting has been convened in the month of March because 2 meeting was unsuccessful.
Month of March.
Coming March.
Do you know the date?
But the first week of March, some development will take place. That's the information because file lying with His Lordship. I've got information about 3 names they have got now because under the new act.
Then the matter will appear after 2 weeks under the same heading. And but if prior to that any development comes, you please mention so that we can keep it in to be mentioned and finish it off.
One meeting was fixed to us, but Honorable Chief Justice was not made available. Then another meeting, membership. Confidential document.
No, I tell you, Dr. Bandyopadhyay, she cannot tell it fully. The matter has been, it is in progress. It is in progress. He cannot.
No, the concealment will not invites interest.
That is because he is a friend of yours. Friends are harder than the enemies. এটাকে 2 সপ্তাহ পরে রাখো, এটা মিস্টার মুখার্জিকে লিস্টে দিও বাবা।
এটা একটু দিত জজ সাহেবকে, এটা একটু দেখতে দিন। This is the order. This is the downloaded copy passed by the tribunal, and in all matters below, this order is passed, irrespective of the presence of the learned advocate.
এটা করছে এই জন্যে যে তার আগে সেদিনকেও ব্রিটিশ আমলের
এখন নিজেকে অফিসিয়েটিং চেয়ার প্রেজেন্ট করে দিয়েছে।
ঠিক আছে।
All right, come under 2 weeks. Come after 2 weeks. Don't make any application for preponement in the week. Let us see what is the development after 2 weeks. If there is positivity in that, we will. If there is positivity towards constitution of a division bench, we will pass appropriate.
My lord. Is there any formal order my lord is going to pass or?
No, we are not passing any formal order. That is an informal communication. After 2 weeks you come, let it appear in the list and Prior to that, if any decision Mr. Mukherjee is taken,
Development.
please come and tell us so that he can be also aware of that. And take it.
2 weeks পরে মানে আবার
Yes, Doctor.
My lord, can it be kept on 23rd like that?
Yes. তাহলে 23 তারিখ রেখে দাও।
23rd
No, sorry. On 13th, 14th, sorry. The 2 weeks shall cover by your lordship's convenience, if it permits, 13th, 14th or that.
13, 14.
My lord, I am extremely suffering.
14.
No, my lord, but kind of one difficulty is here. As soon as the selection will be made by the committee, headed by the Honorable Chief Justice, it will go to the central government. Then as soon as the president signs it, then it will go to the governor. Then governor will do it.
And it will take 2 years.
Because our hands have
I know.
power has been taken away by the central government.
My lord, I am not an outsider. How can I say? How can I oppose him? But I am not an outsider in judiciary. I know how it happens.
Mr.
It will take 2 years. It is actually, my lord, we are ignoring it. It is actually hurting the ego of the judges. The manner of appointment of the tribunal vice chairman.
No, that is not there. You know the administrative process which is undertaken.
My lord.
No, because he should have made the party with the central government.
But the manner in which
President now president is the appointing authority.
These things are not in
The names will be there. One of the name will be taken up by the central government. That will be signed by the president. Then it will come to the governor. Governor will issue the notifications. 2021 Act has been amended. Madras challenge the order before the Supreme Court.
Steps for the interim order. If the interim order application has been considered and disposed of, then we can take a provisions of this.
I took this step, but the order of the tribunal was the MA was to be heard with the original application.
Where is that order?
Then, my lord, again I will have to. So everything is annexed, my lord. I am not hiding anything. Everything is annexed, my lord. I am not. Of course, everything.
All right, Mr. We keep it.
I am quite confident with the case. They are avoiding in the tribunal and they.
No, we are not avoiding. We are waiting for the
They are on 28th
order of the President
March.
of India.
Mr. Mukherjee, we are keeping it on 28th March. There is no development. In the meantime, please come and ওটা ডেটটা ফিক্স করে রেখে দিন।
My lord.
Yes.
Oblige, my lord.
Next.
Lordship, regarding the item number 52, Lordship, I was in 34, Lordship.
Don't mention.
Lordship, the matter has been adjourned for 3 weeks, Lordship.
Yes.
Lordship, there is an urgency, Lordship. Mr. Nilanjan Bhattacharya is appearing. He has the.
Yes. Who is the appellant?
I am for the municipality led by Mr. Tapabrata.
We are appealing on behalf of the appellant.
Who is for the appellant?
Appellant, my lord, we are appealing. এসে গেছে
রেটটা একটা দিবি, হ্যাঁ দুটো আছে রেট। আরে ডেমোলিশন 51 থেকে দেখ, 51, 60, 61, 63 চারটে দেখ কতগুলো ডেমোলিশন অর্ডার দিয়েছে।
ইনিশিয়ালটা বলো,
হ্যাঁ
ইনিশিয়ালটা বলো।
আচ্ছা, এটা একটু জজ সাহেবদের দেবেন। রিট পিটিশন কপি নেই।
So what is the thing? He was not served. Writ petition was not served.
Yes.
Because only the petitioner appeared.
Yes, well, nobody appeared on that day. Well, we prayed for implementation of the order of demolition issued by the municipality.
How the demolition was made,
My lord, respondent, will you keep quiet, sir? We will call upon him to answer. When was the order of demolition passed by the municipality?
2022.
Demolition order was passed in 2022.
Well, I request your lordship to take up my writ petition which has not been annexed. But kindly see, but how many times the order of demolition was passed, directing them to demolish it? How many times? Kindly takes up page 51 of the writ petition once. I have handed up 2 copies. This was done on.
Wait, let us hear you what.
My lord, my affidavit of service.
You are appearing for Boloram Datto.
Boloram Datto, my lord. The problem is that Boloram Datto, filed a writ petition falsely in the name of Boloram Datto, and demolition order has been passed. But Boloram Datto is not the owner of the property, which is going to be demolished by the municipality.
Then who is the owner?
Who is the Gitarani Datto, my lord? I have annexed it. 2 things. It is into apparently 2 deeds. The original owner was Ganga.
Section 5 application. There is a section 5 application.
Section 5 application. I have submitted.
How many days delay?
4 months, 12 days. But the question is that, my lord, give me the opportunity. The appellant is very indigent financially and illiterate. He empowered to conduct the case will learned advocate. The problem is that, and his mother is 82 years old and absolutely confined in the bed. And
Where
that
is the demolition order? We shall come to the
demolition order একটা copy to dilam.
have you not annexed with your say application?
My lord,
when was that communicated to you? Where is the demolition?
Page 60 of this stay.
Page 60 of
60 of this stay application.
19th of January 20.
19th of January 2024.
Who is Ashok Chattopadhyay?
Yes, I am also Chattopadhyay.
এইটাই লাস্ট অর্ডার এনেছিল এটা তো রিট পিটিশনে ও তো অ্যানেক্স করেনি
So it is the first demolition order.
That document he has not annexed.
My lord,
not annexed. In the writ petition, we have annexed. Kindly takes up the writ petition. There are 2 copies.
Page 61.
Page, no. Page, I tell you, lordship. Page 51 onwards. 51, 60, 61, 63. 51, 60, 61, 63. 4 notices.
Page 51.
51, unauthorized construction. Then, 60, 60. You are directed to dismantle.
One septic tank drain.
Yes.
And one steel door.
Yes.
He has fixed on the common passage.
Yes. এই ছবিটা
It
যাচ্ছে
is the thereafter in the photo pages.
Then turns to 60, 60.
Bongshidhar Nandi.
Yes. The appellant. No, but Bongshidhar Nandi is me.
The complainant.
Complaint.
He filed a 144.
Kindly turns to 60, 60.
My lord, 2 things have been suppressed by the writ petitioner.
আপনি বলবেন আমি দেখিয়ে দিই just
Let us understand.
page 60. This notice was given below 9th of June 2022. Then 61 once again 27th of July. দাঁড়াও wait.
Now,
Then
Mr.
63.
Bhattacharya, show that this order was passed by the learned single judge. You serve notice upon them. It does not. It says none appears for the respondents. What service was effected upon the private?
Yes, everybody has been served, but
unless you show us the affidavit of service.
Kindly, give me 1 second. তোর কাছে আছে কপি?
Because the demolition orders are starting, as you have showed, from 2019 onwards. You ultimately came in 2023. Now, the first day the matter was disposed of, none appears for the response.
Lordship.
They did not serve him any notice.
Yes, we have got the notice, but the question is that the appellant is very indigent and illiterate. He did not know the procedure of the court. He entrusted.
Do not know the
No,
procedure
my lord, my
of
lord.
91. Don't make this submission. You are a illiterate, such an illiterate person that you cannot understand from 2019 that a demolition order is being passed.
No, in demolition order is in connivance with the municipality and the writ petitioner is going on because the property is not in the name of Balaram Datta.
Did you ever challenge the order?
Yes, obviously. We wrote so many letters to the municipal.
Writing will not help. Did you approach this first?
No. I gave submission before the municipality chairman whenever demolition order was coming in consideration of the.
So on what ground we will stay that order? You tell us.
No, my lord, be kind enough. Practically, there is absolute suppression of facts from the side of the writ petitioner. They have annexed 144 was pending before the special executive magistrate. That was dismissed, but suppressing that fact, they have annexed this order in their writ petition, page 71. I give the copy of this, and on the basis of this, they have suppressed the total matter. 144.
We are asking you one simple question.
Yes.
When the writ petition notice was given to you,
yes,
and you knew that the matter is before the court, why didn't you appear on that date?
That is the problem. The appellant.
Your problem is
he entrusted one lawyer to conduct the case, but he did not present. He did not. He was absent at the time of hearing, and it was.
Where in the stay application you have stated that?
I have mentioned in the section 5 petition, my lord. Section 5 petition, my lord, be kind enough.
You have never appeared before the
only on the
not only that,
only
before the municipality on numbers of occasion gave notice.
Yes.
We were trying to find out whether there
page
is
33, your lordship kindly have a look.
Yes,
Page 33 of the writ petition. A second, sir. A second. Page 33, the stopwork notice, it was in 2014.
No, from 14, he is harassing the
Me.
person who is not the owner of the property, and they have not submitted any document in support of the common passage.
Neighbors, next door neighbor.
But this is not his property at all. He has not entity.
Common property cannot be.
No, it is not a common property. My lord.
Over common passage, one safety tank and one gate.
Your conduct is not
Can you see the
proper.
picture?
Your conduct is not proper. You are filing an appeal after 4 months delay, blaming the advocate. And you are coming here and saying tomorrow it is going to be demolished. You kindly have an illiterate person.
No. After 4 months now, I have learned it only after Act 24, after having the notice from the municipality.
That is why you are powerful. You will not.
No.
I will not appear.
The appellant empowered the advocate who was not sincere. He only for his negligence, the matter was absolutely in the dark.
We cannot grant you interim order unless we allow the section 5.
Section 5, sir, this is the ground, sir. Only for the laches of the advocate, the appellant cannot be suffered, my lord. And this is the problem. Question is that there is absolute suppression from the side of the writ petitioner. They suppressed 2 cases that was dismissed, but they have not mentioned in that.
Which case was dismissed?
I just
144. 144 case.
You filed 144.
And yes, there was a
dismissed. That was
dismissed.
He also subsequently filed 144.
Kindly forget about 144. Kindly see,
144.
it was dropped because the time has lapsed.
No. They only on the
You
pocket.
are very much aware that a dispute is going on. regarding
Yes, yes, they
construction of
preferred 144.
You
Now,
are-
No.
yes, yes.
They have referred to 144 and on
You
their
file an application.
they have suppressed the matter.
File an application under.
Prior order has been.
To annex this to your stay application.
This is
You
their
are
interim.
appearing before the High Court. You don't know the procedure.
I have annexed the entire
Where have you
order.
annexed in the stay application?
Stay application I have added, annexed
So,
the order, yes,
to us.
paid 40. Stay application paid 40. অর্ডারটা কোথায় রাখলাম? অর্ডারটা কোথায় দিলে? দুটো ছিল তো।
দিলে তো সাহেবের কাছে দিই। এই যে অর্ডার 40
435
বললাম না,
435 তো প্রশান্ত দত্ত কে? ও আচ্ছা, বলরাম দত্ত, আচ্ছা হ্যাঁ হ্যাঁ হ্যাঁ।
বুঝতে পারছি।
এক মিনিট দাঁড়ান, আমি বলে দিচ্ছি।
পটুয়ারি কি মিউনিসিপালিটি পার্টি ছিল নাকি?
না না না,
50টা পড়াবে।
এইটার নাম্বারটা কত বাবু? শুভ,
এই যে 40
435
My lord, 840, they applied for the 144 and they have submitted a prior order suppressing the court that the finally dismissal order that was not submitted in the writ petition.
Page
40 and page 50. An order will get page 41. 17/11 by 17, 11, 12, 22, this matter was dismissed, but they have capitalized the order, prior order, and submitted before the writ petition.
It was dropped.
They moved the revisional application.
Bring some more advocates. Bring some more advocates and start submitting. Go and take your seat there. When senior is appearing, he's done.
I'm
So
happy.
go and take your seat.
There are so many people telling he
No procedure is followed. Nothing.
দাঁড়া পেজ 50 এটা দেখি পেজ 50 তে ডেলিভার এটা দুটো কথা ছিল পেজ 50 দাঁড়া দেবো 41টা হোক আমি সে বলছি উল্লেখ করতে ছেলে হয় ছেলেকে 14 সাল থেকে একটা আছে যতবার দেখেছে একবার যাওয়ার ক্ষমতা 14 সাল থেকে একবার হ্যাঁ 54 এর অর্ডারটা আছে হ্যাঁ সেটা একটু যে দেখতে পাচ্ছি ডিভিশন কি ডেমোলিশন হয় 144 ডেমোলিশন হয় কাউন্ট রিটিং করতে দাও সার্ভিসটা And how will you prove that Balaram Datti is the owner of the property?
We are not,
But the question is
no,
that
no, listen to us. Listen to us first. Demolition dispute going on from 2014. We are not concerned how whether from the will be probated or not. These are all civil matters. 2014 till 2023, the dispute continued. Today, the regular division bench is not sitting. The notice which you showed us is of 23rd February 20.
Yes.
Wait, 23rd February 2024. You did not bother to immediately approach the court and say that they have given me a 7 days notice that they will listen to us first. All these facts are admitted facts. Now, why should we exercise discretion in your favor? Tell
But
us.
now, should I be
Yes,
permitted?
yes.
The question is that notice has been served on 23rd February, but the application for appeal was submitted on 12th February, but it has not been listed, and subsequently the notice has come after 23rd, and naturally it has been listed today, and I am come here with the document, sufficient document to corroborate that they have suppressed the matter. 144, they submitted one criminal motion that also been rejected.
Oh, why are you thinking is the possible property?
No, property was put. I have
You hear
this put money. There is allegation only for the ill motive of the.
go before the regular bench.
No, no, madam, my lord, please be kind enough to stay the matter at least so that we can go for the disposal of the application. Delay only for the latches of the advocate. That is not.
But has they ever challenged the order of demolition?
Yes. Yes.
Never.
Challenge the application. We have
Never.
submitted.
It is my writ petition who I approach the court for execution of the order.
Definitely, that is why we have. They have suppressed the matter. The writ petition has been submitted.
You go and pray before the municipality.
No, my lord, this letter will be clear. We submitted our prayer. No, demolished only for the false allegation.
No.
Whether any document to support that common passage is writ petitioner, whether any, my lord, be kind enough to at least give me an opportunity. If I not, I will be prejudiced if I do not.
Stop work notice was given in 2014. Today we are in 2024. 10 years, but they did not have the time to come to the court and ask for stay.
No, on the basis of the 144 order, municipality is
questioning the sustainability of the order.
My lord, be kind enough to.
Of the order dated September 25, 2023, first.
We are rejecting your prayer.
No, my lord, I will be prejudiced, my lord.
Wait, you pray for an adjournment, we will send it to the regular bench. Choice is yours. If you want an order from us, we are telling you we are not in your favor. Now it is your choice.
When liberty be given?
Huh?
Liberty, please give me an opportunity to go to the regular bench. 144 ধারা ক্যাপিটাল করে মিউনিসিপালিটি কনাইভ্যান্স করছে, ডেমোলিশন করছে। Section 218 clear that opportunity to prevent দলিলগুলো দিন, দলিলগুলো।
On the pair of Mr. Chakraborty, Tapabrata, learned advocate appearing for the appellate. ঠিক আছে, তার matter stand released. Stand adjourned. ঠিক আছে, release the matter before the honorable regular bench. Before the regular. Before the regular.
দলিলগুলো, টুইলগুলো
on 4th. Before the regular bench on 4th. Demolition order থাকবে সেটা তো ইমপ্লিমেন্ট করবে।
দলিলগুলো দিয়ে দাও।
Consent পাবে।
বলবে on the prayer of Mr. Chakraborty, the matter stands adjourned. Is the matter.
আর ভাঙবে কোথায়? আর ভাঙবে না। আরে ভাঙতে গেলেও তো শক্ত আছে, গীতা রানী দত্তের প্রপার্টি। 218 করলেও গীতা রানী দত্তকে অপরচুনিটি দিতে হবে।
Okay, try your luck.
On 4th of, on release the matter before the regular bench on 4th of, 4th of March.
4th of March.
Yes, next.
রেগুলার বেঞ্চে 4th of March. কি 4 তারিখে 4th of March এর
Lordship, I am filing the supplementary affidavit of service.
Have you served it?
Yes, Lordship. Lordship, Mr. Rajnil Mukherjee is appearing on this matter, but Lordship, Mr. Rajnil Mukherjee is appearing on this matter, Lordship, but he has some medical exigencies. Actually, he left the court. So kindly keep this matter tomorrow, Lordship.
Have you served the supplementary affidavit upon your other side?
Yes, Lordship.
Where is the service?
Yes.
So you are not inclined to do the matter today.
No.
Then you keep these copies. We are list it 3 weeks ago. On the prayer of on the prayer of the learned advocate appearing for the petitioner, the matter stands adjourned. List the matter 3 weeks since. List the matter for further consideration 3 weeks since. Yes.
My lord, I am for the petitioner, item number 57. May I place my case?
Yes.
My lord, in this matter, learned tribunal has passed an order on 4th July 2023, my lord, without appreciating, quashing and setting aside the order of General Manager Southeastern Railway, without appreciating my lord, the issues involved in this matter in its proper perspective in terms of relevant circular order and judgment of the Honorable Supreme Court, and directing the Eastern Railway Administration to fix up the pay after stepping up of the pay of the respondent herein at par with his junior SS Maharana with consequential benefit within a period of 2 months. This is the case of stepping up of pay. Against the stepping up of pay, Union of India has filed this. I am coming to the grounds one by one.
The
ground and बोली ही नहीं हंसने की बोल देना. I have not placed my case before placing my case. Don't.
This is Moharaj.
One thing, may I just
You have already returned.
may I just say one thing, mistakenly.
Answer our question first.
Mistakenly, I brought a wrong brief, not this one.
You have returned.
Yes,
You
I
don't
have
know.
returned.
You don't know that.
But But I just cannot recollect this matter.
Then my lord, kind,
Come after on the next date, we shall.
my lord, either tomorrow or after 15 days, because I will be very busy in my personal affairs, so my lord. After 15 days or tomorrow.
On 14th March, it will appear.
Yes, yes, my lord.
14th March. 14th March.
Obliged.
On the joint prayer of the parties, the matter stands adjourned. So please the matter for further consideration on 14th March.
ঠিক আছে। Okay.
That's very good.
Yes, next.
হ্যাঁ।
শুধু একটা ফাইল দাও, শুধু একটা দেখিয়ে দাও তাড়াতাড়ি। ওই করে হুম। No one appears on behalf of the petitioner and no accommodation has been.
58 minute, Mr. Sudip Kumar Datta, Sudip Krishna Datta is appearing on behalf of the respondent, my lord.
No one appears on behalf of the petitioner and no accommodation has been sought for. So, please see matter 3 weeks hence. Yes, next. এটা তো ফ্রেশ মোশন না কাছে নতুন মোশনে দিয়ে দিতে হবে পেনশনের অর্ডার বললে স্টেট হচ্ছে under the motion. No one appears on behalf of the petitioner and no accommodation has been sought for. Please the matter for further consideration under the heading quote unquote motion within bracket central tribunal করে দেবে 3 weeks since. তাহলে তাই লিখে দাও no one appears বলে দাও no one appears on behalf of the petitioner and no accommodation has been sought for. Let the matter go out of the case for the present stop liberty to mention.
After 3 weeks, কালকে লিখতে লাগবে but mention after 3 weeks পরে লিখি চলে আসে না বারবার 3 weeks হ্যাঁ
নেমে যাবে
ওই নামাতেই চাইছি
হ্যাঁ নেমে যাবে এখন লিস্টের বাইরে
নামাতেই চাই যারা আসল তাদের গুলি করি যারা
একটু মনে রাখবে মেনশনিং যখন হবে একটু মনে করিয়ে
4 weeks করে দিতে
হ্যাঁ সেটা
matter 4 weeks
4 weeks entry করুন তাই
yes
Order for the respondent.
Another petitioner, madam.
oh come next week এই দেখে দাও
এসে গেছে এটা কি তোর
Mr. Sannal, there are 36 appeals, na?
36
I'm not. Please tell us the same order is under challenge before the appeal, individual appeals.
I'm to assure
We are at a mess. We do not know that what is the state of affairs because we find in the list there are 36 appeals. Please do us a favor, at least tell us.
No, I will.
You placed only one order of Justice Gangopadhyay, which you showed us. That is in respect of Brahmo. But we do not know what are
Well,
the
I will ascertain it and I will tell you.
That is the only order. That is the only order.
only order.
If at all.
No, just for because if there are separate orders,
The order under it.
no.
No other order.
Mr. Sannal, why don't you ask your junior
I
to
will
help us?
ascertain and tell you losses by person. না ভালো করে দেখ 36 অ্যাপিল আমি তো এতগুলো জানি না I get it.
There are some matters who
I'm only one of the matter.
You are for the
They are not successful candidates now. Now, what has happened when we leave to appeal application for intervention? We have made it. That time, my lord, now our a number of persons were there. Now, my lord, that time we were not aware that whether our names are in the list or not in the final list. But ultimately, when the commission has published the called for the counseling, etc., then major portions are of our my clients have become successful apparently, and the others are not. That's a different thing, my lord. I am arguing for the my lord, arguing on the point that
Mr. Vandada, can you ask your junior to make this list that how many persons whom you are representing
Yes, I will.
Are already there in the merit list and have been called for counseling?
My lord, I will.
First,
I will.
And how many candidates have not featured in the merit list for whom you are appearing?
That's all right, my lord. But I will be arguing, my lord, on the point. I am very clean, my lord, very clear in my mind, and from the very beginning, I said to my clients, the selection process is right. My argument is
yes. We have fixed consecutive dates so that we can finish
it. No. I am not on. I am only arguing on this point. On this, whether someone have become successful or someone have become unsuccessful, it is insignificant. When on the point of law, I will be going on arguing. Nothing more than that. If benefits goes to us, successful goes. Our benefit doesn't go to unsuccessful.
Yes.
Mr. Sannal, the application. You said application.
And the list of addition party applications.
Your junior was preparing.
Okay.
Which application has been filed in connection with which appeal? Addition of party. Or
the appeal number and your CAN number and how many applicants are there. You are persons who were all in the select list in the earlier process. You were all in the merit list. So please make that distinction somewhere. Then you are not exactly similarly situated. So why don't you make a chart to that effect and hand it over to us so that we can make appropriate statements while allowing the application? Unless you do that, we are helpless because we don't know how it becomes very cumbrous. No. Yes, Mr. Sannal.
119 applications.
Lord, I was placing, my lord, the point of my lord, enlargement of vacancies that I was placing yesterday, my lord. The last, the point.
That you have finished. Reservation and vacancies you have finished. Manipulation you are arguing.
The vacancy I have not finished, but
Mr. Sannal, what we propose to do, you complete your argument. At the time of reply, if you want to point out any other we will ask Mr. Bandopadhyay to deal with that and finish it up. any further thing, because after you, Mr. Bhattacharya will be there. So if you remember that some point has been left, you come and tell us, we will hear. What you want to place anything else on vacancy position? That vacancies you have argued, we have taken note of that.
Alright, your lordship, my lord, I am going to the next point, but when I will cite the judgments, I will just sum up.
All right.
My lord, before placing the next point, my lord, my humble submission, if your lordships allow me to place the judgment of the earlier round of litigation, Justice Bhattacharya's judgment. Your lordship will get it at my lord, this bunch.
Yes, yes.
My lord, page 30.
We have already got.
My lord, I will be on the relevant portion, not the entire judgment, your lordships. Boss, উপরে boss.
কোনটা দিচ্ছিল সই করতে হবে? Yes, yes.
Now, your lordships, my lord, kindly come to my lord, internal page of the judgment 15 and running page 44, probably. Internal point. My lord, the contention number 1, that exactly, my lord, I am repeating again. With my lord, different facts will be a little bit of different now. But the point remains the same. Now, your lordships will find, my lord, I have to place it, my lord, this point, how the earlier round of litigation it was dealt with by the Honorable Court.
We have read it now.
My lord, unless I
Anyway, all right.
My lord, counsel for the petitioners has divided this contention into 2 categories, namely female general, female OBC B, male general, male SC, male OBC B, and male OBC A and B. The charge is that 21 of the 16 writ petitioners, despite scoring higher marks in the aggregate of the academic qualification, professional qualification, and TET weightage, failed to find a place in the merit list as opposed to candidates with a lower aggregate which were selected for the merit list. The same pattern is repeated for the other categories as well. It is also urged in that in some cases the writ petitioners were not even called for verification, which is before the stage of interview of the personality test. Answer of the commission. Pursuant to an order passed in a writ petition being WP number such and such, Nandini Singh versus State of West Bengal, dated 16th January 2019, the commission decided to reassess the TET marks of the petitioner in WPA number 1859. Now, this confines only to one single writ petition. The commission thereafter found that the marks of all candidates were required to be reassessed. All candidates, my lord, candidates means who appeared at the TET. All candidates required to be reassessed, and accordingly decided to reassess the OMR answer scripts of TET 2015 of all the candidates. As a result of the assessment, the TET marks of a large number of candidates were altered. My lord, I placing this for the purpose.
It was in 2011 as well as in 2000.
My lord, this is in connection with 2015 TET. One TET 2012. Other one, my lord, there is 2012.
So reassessment was made only in respect of TET 2015.
All candidates, your lordship. This is the submission or the case of the commission.
No, the candidate might have placed the 2012 TET report. Some candidates may have relied upon that also.
But that's another point, your lordships. Suppose, your lordships, I have placed 12. Now, in this exercise, whether it's legal or valid, another aspect. Suppose my marks exceeds, increased.
Upon
reassessment, then how?
According to you, if that would have been also reassessed, you would have got more marks.
That's not the point. Point, my lord, commission says I can rely 12 or 15. This is one of the point. It doesn't, my lord, relates to all of the petitioners. Now, suppose, my lord, I have 2 TET. I have given, my lord, when I fill in the form, I find my 12 marks is higher. I opt for 12 TET. Now, this after exercise of this revision or reassessment, if my malad increase 20-15 marks, then I will be deprived of availing that benefit of 15 marks.
Exactly. For that reason, this was found to be bad.
No, this is one of the, not only that. This is one of the reasons. My point, your lordships, there was an exercise. Why I'm saying this, my lord, I will place the other facts, then it will be clear to your lordship. Kindly take note that there was one reassessment before the new process. Under the old process, I'm clear to your lordships.
Old process.
Old one that was quashed by the High Court. Then the de novo process from Rule 12(2) by this judgment.
Yes.
So this reassessment was carried out by the commission at the time of the first process. First process
Yes,
means?
yes.
That's your lordship. Now your lordships.
Now, what they have done this time, they have
Again reassessment when going on and on.
Oh, it is continuing.
That's the picture I will tell you lost from their affidavit.
So very good. You are representing 45 persons in Brahmo. How many of you rely
Not
upon-
Malad Brahma, others Malad added parties I am also representing.
Please give us a list, na, that you. These are very complex. At least you can formulate it in a chart.
But I will
that
give it.
I am 55 persons appearing. Out of them, 20 have under TET 2012 and 30 had been TET 2015. This we are wondering, but your larger argument is this could not have been done. That would have prejudiced me. That is your argument, because if 2012 at the time of filling up, I found that I got X number of marks. In 2015, I put that marks in the sheet. Now, upon reassessment of 2015, some candidates may have exceeded that mark also. That is your argument.
That's one argument, but not all. But I place kindly your losses. I get your losses point. I will clarify it, your losses, in course of argument. I get your losses. Not that I have not got it. I get your losses. Kindly allow me, I proceed, I will do it, your losses. Malad, kindly see the next page, Malad. Manner of selections have been quoted, your losses. This part. 7 manner of selections. Selection to the post of such teacher, except physical and educational work. This is the part of the rule. Shall be made category-wise on the basis of merit, state, academic part. Malad, I have placed it. I am not repeating.
Yes.
Kindly see the findings of the court. The sequence of events with regard to the alleged reassessment of the TET 2015 weightage of candidates across the board.
Maybe internal page 18, last paragraph. That is what you are wanting to say. Hence, there is every possibility that it.
No, not on that. This is one of that. All that I'm trying to say, your losses, kindly see this. Here the court held reassessment cannot be done because of the certain reasons. Kindly consider this. The sequence of events with regard to the alleged reassessment of the TET 2015 weightage of candidates across the board pursuant to a writ petition filed by a solitary candidate is required to be highlighted. The order dated 16 January 2019 passed in such and such writ petitioner directed the commission to consider the representation of the writ petitioner and pass a reasoned order within certain time frame. The commission's argument that it decided to reassess the OMR answer sheets in TET 2015 of all the candidates besides the writ petitioner number such and such is not supported by any document, which would show that a considered decision for reassessment was taken by the commission or its chairman at the relevant point of time based on certain factual findings. Then, there are several factors which are of significance in the case, sought to be made out by the commission in its affidavit affirmed on 13th October 2020. First, the order dated 16th January 2019 was in relation to only one aggrieved candidate. The fact is reinforced by the report of the chairman of the commission dated 29th November 2019, wherein the writ petitioner was declared as state qualified in compliance with the order of the court. Since there is no indication either in the order passed by the court or in the report of the chairman of the commission filed after 10th months from the date of the order, that the commission had reasons to believe that the other candidates had similarly prejudiced as in the writ petitioner number such and such, it was incumbent upon the commission to produce the evidence of an unanimous decision or a resolution taken in presence of or with the consent of its members for revisiting the TET marks of all 2,28,670 candidates. The affidavit of the commission does not enclose any such document beside the decision taken with reference to the writ petitioner number such and such. Second, the commission has filed several affidavits in response to various allegations raised by the writ petitioners since the time these matters were taken up for hearing. Pursuant to the order dated 1st October 2019 permitting the commission to publish a tentative merit list and the petitioners to communicate their objections and representations, the commission filed a comprehensive affidavit dated 23rd December 2019, which did not contain any explanation on the decision to reassess the TET marks of all the candidates. The first time the commission indicated that such a step was taken in January 2019, which by way of submission in October 2020, followed by an affidavit of 9th October 2020. The commission has not given any satisfactory reason as to the basis of its failure to disclose such a relevant fact which would have a bearing on the fates of the candidates who had taken the test. Third, the commission cannot now contend that the conduct of TET is a different process and not connected to the present selection process. Rule 12, Sub-Rule 5 of the Rule 2016 gives weightage to the candidate's TET marks and makes it clear that the TET weightage would have a bearing on a candidate being selected on the merit list as detailed further in Part A of the Schedule 3. Therefore, any alteration of the TET marks would directly impact a candidate successfully proceeding from the interview list to the next stage of the merit list under the Rule 12.5. Fourth, no notice or intimation was given to the candidates prior to carrying out the reassessment. Third, the candidates who are also not informed of the result of reassessment. This assumes importance since Clause 11 of the information brochure published by the Commission for candidates appearing for the state-level eligibility test 2015 specifies that no request for rechecking, reassessment, reevaluation, or scrutiny of OMR seats will be entertained. No correspondence in this regard will be entertained. But this is my case before your lawsuits now. I will take your lawsuits to their affidavits that this has been discarded by the court, this reassessment. Though the reassessment was carried out in respect of all 2 lakhs, more than 2 lakhs candidates who appeared at the TET. Therefore, your lawsuits kindly consider whether the same plea can it be taken by them. This part of the judgment has been affirmed by the division bench. Taken out by some of the candidates, this appeal was taken. So therefore, apart from this, your lawsuits kindly consider, I appeared in TET. I have been given a mark sheet. Can they alter it? And that too, in respect of all candidates. Then there is the the language would be
ultimately, what did she say?
What
is the ultimate finding of the court?
On this? This court, this cannot be done, reassessment.
Please read that.
That your lawsuit now. Hence, then the paragraph your lawsuits. And there is every possibility that a reassessment of 10/2015 may result in a candidate being deprived of the choice given to him or her under Clause 16 for information brochure.
Yes.
For example, if an candidate who has opted to give his marks obtained which are higher than competent, this cannot be done. Therefore, this is the finding of the court. The answer of the commission. The conduct of TET and reassessment of marks is an independent method of assessment conducted as per National Council for Teacher Education guidelines and has no connection with the recruitment of teachers in upper primary schools. Violation of rule. Now your lawsuits kindly see the court. The primary thrust of second condition is that the candidates with inter and TET weightage have been, this is another set of case. Now this is the next case that the lower inferior candidates have been included. This is the finding in regard to reassessment of the court.
Yes.
This is one of the point taken. Now your lawsuits kindly take up with affidavit portion. This
এটা যেটা হলো যে রিঅ্যাসেসমেন্ট অলরেডি যেটা কি বলছি যে রিঅ্যাসেসমেন্ট অনেকবার হয়েছে তারপর
My lord, I just, my lord, continuing like this. My lord, I just place it, your lordship. Let me place the facts in regard to that, then, your lordships. My lord, the first affidavit, my lord, your lordships will find this bunch. I have given the commission affidavit portion. Spiral binding, your lordships. One. No, this is in regard to judgment. My lord, I hand up, my lord, the two sets to
That is admitted. What you are want to take, you are wanting to take us to that portion.
affidavit. No, this is, my lord, de novo process. That process was closed. Rule 12 to, from the stage of Rule 12 to directed to be conducted.
What you are showing us?
My lord, I am showing now they are saying that upon reassessment, again reassessment,
in
this second process, am confined only in regard to the candidates who are called for interview, there is a change of marks. My mark sheet is being disregarded by the commission, given by the commission. They say this doesn't tally with their surveyor, with their scanned copy. Then what is the correct? Well, this takes us to do entire state proceedings.
Affidavit they filed in your appeal.
Appeal.
To us.
Now your lordships kindly take it up. Page 6, serial number 6, page 90 to 1558. This is the first affidavit of the commission. I'm 12th September 2022. This is the first. Well, this is the affidavit affirmed on 12th September 2022.
Yes.
Now I'll be on the relevant portion of this affidavit. Now, your losses, kindly remember, your losses, the first order of this appeal court permitted them to take interview of the candidates and the same time grievance mechanism procedure directed to be, and to keep all the records intact for the production before your losses for consideration. That was in a nutshell the order. There are 6 points. But this is the nutshell. Now your losses, kindly consider paragraph 5 onwards, page 92, running page. Being agreed by the said orders, several appeals were filed, one of which is Rajiv Brahmo's appeal, wherein the Honorable Division Bench was pleased to pass an order dated 20th July 2021, giving certain directions upon the Commission with regard to conducting grievance redressal mechanism and preparation of panel. In compliance with the said directions, the Commission concluded the grievance hearing of about 18,536 candidates on one hand, and held the interviews or personality test of 15,000 candidates on the other hand. Well, this was carried out in accordance with the directions of the Honorable Division Bench.
Though only 12,000 appeared. In the
Though only 12,792 appeared for the same. Out of 15,000, in interview appeared 12,000 such and such candidates. Now your losses kindly, next page, paragraph 6. As far the personality test part is concerned, a total number of 15,436 candidates were called for personality test, out of which 12,792 candidates appeared in the said personality test. Out of the 12,792 candidates who participated in the personality test, 253 candidates were inadvertently interviewed by considering the wrong test score.
That is of 2011.
I don't know, my lord. This is not clear. This is very cryptic. This is in the second process, for which after correction, 6 candidates can found to be within the zone of consideration, and the remaining 247 candidates were not. And therefore, the interviewers are to be cancelled as they were wrongly called for interview. Then your lordship, paragraph 7. As far as the grievance redressal mechanism is concerned, I say that the Commission received a total number of 18,356 representations from the aggrieved candidates who were given personal hearings, and reasoned orders were issued to all the candidates who attended the personal hearings. It may be noted out of 18,356 candidates, 3,329 were absent. They called for hearing according to them. 8. Out of the total candidates who were given personal hearings, 1,448 candidates who had partly uploaded their academic testimonials had genuine grievances, and after being allowed to upload their remaining documents are now within the zone of consideration and eligible to be interviewed. There are also another 1,098 aggrieved candidates who were not allowed to participate in online verification as they had uploaded only their direction of the Honorable Division Bench dated 18th May 2022. The said 1,098 candidates were allowed to upload their academic records for verification, and after the said verification, it was found that 99 out of the said 1,098 candidates were within the zone of consideration for participating in interview. In addition to the said 1,448 candidates and 99 candidates who are now eligible to participate in the interviews, and another 38 candidates are also entitled to participate in the interviews due to direction given in various court cases. Hence, a total 1,585 candidates are now eligible and entitled to participate in the interviews to be held in connection with the upper primary selection. For the above reasons, paragraph 9, this honorable court may graciously be pleased to allow the commission to do the following so that the order dated 20th July 2021 read with 10th November 2021 may be complied with and the final merit list may be prepared and produced. Now, kindly see what are the pairs. To remove the 233 candidates referred to in paragraph 6 from the interview list, then your lordships, 2. Upload in the interview list with all details of 1,585 candidates who are now eligible to participate in the interviews, and also to interview of the said 1,585 candidates. So far, the final merit list may be prepared by the commission. Now, next paragraph 10. By allowing the commission to hold the interviews and personality test of the said 1,585 candidates, there will be no violation of the rules of 2016, which are under Rule 12, Sub-Rule 4 provides the interview list should be prepared in the ratio of 1:14 of the final vacancy as per the said rules of 2016. All the candidates having the same marks as the last qualified candidate shall be called for the personality test. I say that all 1,585 candidates who are now eligible to participate in the interviews or personality test all have the same marks as the last candidate belonging to their respective category, and hence by including them in the interview list and holding the interviews, there is no violation of the said rules. Therefore, my lord, after grievance mechanism was over according
last line, even if
the total number of candidates exceeds the ratio of 1:1. That I told your lordships yesterday. If the last candidate having at certain marks and the similar other candidates having the same marks, all of them to be called for. Even if it exceeds 1:2. There is no dispute, my lord, with regard to
yes.
My lord, this is the first affidavit by the commission. They are included. My lord, kindly see the second affidavit, page 55.
These machines, AC machines can be top, it's extremely difficult. AC machine.
ও জিজ্ঞেস করো না, ডেকে জিজ্ঞেস করো কে আছে পিডব্লিউডি
Centralized, then problem.
সেন্ট্রালাইজড
Huh? No, আমার এখানে না,
You can shift the ends, Mr. Bandyopadhyay.
No. Which I can shift, but I cannot shift the side. That's the whole problem. I cannot shift side.
No, your entire side will go that way.
No.
Mr. Sharnal is arguing now.
No, whatever
Commission has done this, done
whatever
that.
is the consequence, no side shifting. Whenever you have taken a side, you have to.
No, we didn't say.
No,
As
but
you
I am
had implied, you said.
Whenever we have taken a side, then the side has been maintained.
Yes, Mr. Sharnal.
We agree.
Yes.
My lord, the second affidavit, my lord, affirmed on 27th March 2023 at page 55. My lord, I take your lordships to the relevant portion at page 58, internal page 4, paragraph 7.
Yes.
Now, paragraph 7, my lord. In compliance with the direction given by the Honorable Division Bench in its order dated 30th September 2022, the Commission concluded all pending interviews, which included, in addition to the 1585 candidates, 4 more candidates who had been inadvertently left out. The Commission also cancelled the call letter of one candidate who had inadvertently been called for personality test. Hence, in the second phase of the interview or personality test, 1585 plus 4 minus 1, 1588 candidates were called for interview. My lord. Hence, the total number of candidates who were called for personality test by the Commission were 17024. Both, my lord, including first phase and second phase, according. However, the total number of candidates who appeared in the interview were 14052, less 233 ineligible candidates who were removed with the leave of the Honorable Court. Therefore, my lord, total candidates called for 17024 and appeared 14052. Then, your lordships, next, paragraph 9. After completion of the interviews of all eligible candidates, my lord, this is very important. After completion of interviews of all eligible candidates, the Commission took up the task to recheck various aspects of each aforesaid 14052 candidates. The said exercise included a complete reevaluation or scrutiny of all relevant documents, including the scanned copy of original OMRs of the candidates who participated in the TET 2014 by an independent agency. But pause here for a moment. Therefore, I came to know after this affidavit for the first time that my original OMR sheets are no longer available. Board Commission proceeded on the basis of scanned copy. The question will come up whether that copy belongs to me or not. Then, your lordships, however, the OMR sheets relating to TET 2011 were not scrutinized, as the TET 2011 examination was conducted long back and all candidates have been issued mark sheets and certificates. But here, my lord, we have been given also mark sheets, 2015 candidates, e-mark sheets. After re-evaluation and scrutiny of the OMR sheets of TET 2015, it appeared that there were 3 missing OMRs which could not be freshly evaluated. Kindly see, my lord, each language, then again freshly evaluated. First evaluation was done, my lord, earlier verification of all. What is the meaning of that evaluation? Even if you carry out the second, and there is a second change, and that confines only to the interviewing candidates. Then, your losses, further certain irregularities were detected with regard to the OMRs of 1463 candidates who went out of zone of consideration. I'll pause here for a moment. Out of 14052, these 1463 candidates were kept out of zone of consideration because of this rechecking, so-called rechecking or reassessment. This is also done, my lord, without any notice to us. The question now come up, can the Commission reassess my OMR sheet on the basis of scanned copies?
Yes.
The irregularities include caste category match of 2 candidates.
Yes.
Then second one, my lord, the mismatch of marks in case of 559 of the 1460 OMR seats and defaced OMRs in case of 902 others, for which 1460 candidates have been treated as ineligible. My lord, on the base, my lord, I take your losses to the 2 point. Mismatch of marks with what, my lord? I'm putting a question to myself. I will proceed further in your losses, your losses will be enlightened with this fact. Their mismatch of marks, they say the marks in the scanned copy is one and their server is another. And the other things, your losses, in respect of 902, defaced OMR sheets. Whether the OMR sheets was defaced and how, can it be ascertained on the basis of scanned copies when the originals are not available? Then, your losses, after removal of the said 1463 ineligible candidates, the total number of candidates who successfully appeared in the interview and are fit to be included in the final merit list is 12589. The final result of the re-evaluation and scrutiny reveals that only 12589 candidates are now eligible to be included in the merit list within bracket panel plus waiting list as shown below. Then your losses, they have charted it. It will take your losses to the same figure. The point is, your losses, what happens in these? OMR sheet, I take your losses a little time on this. Can you confine your rechecking of OMR sheet for the second time at all to only the interviewing candidates? Can you do that? Now, suppose if this rechecking your losses health is good, and if this rechecking is extended to the other candidates who appeared in TET 2015, and if they get their marks increased, then they will come within the zone of consideration. This is a public employment.
Yes.
Then your losses will kindly consider the next page. It is pertinent to mention here that out of the said 12589 candidates, 3 candidates in the first phase of personality test held on 23rd July 21, 25th July 21, and 31st July 21, respectively, were unable to reach the office of the commission within the time when their interviews are scheduled to be held. However, the said 3 candidates were allowed to participate in their respective interviews on the same day, later on signing the attendance sheet. Then your losses, paragraph 10, your losses consider only. In the instant selection process for upper primary teachers, there are total number of 369 different merit lists after taking into consideration the different subject, medium of instruction, caste category, and gender category. For the purpose of preparation of the said merit list, candidates are called for personality test, interviews in their respective categories, for which an interview list is prepared in the ratio of 1:1.4 of the final vacancies. In some of the categories, it often happens that the ratio is not met for want of eligible candidates, while in some of the categories, the ratio is exceeded as all the candidates who got the same marks as the last candidate who accumulated. This is not the correct picture. However, as already stated, there were 1463 candidates whose candidatures after the interview and personality test were cancelled, as on rechecking a mismatch of the TET 2015 marks were found. I take your losses, kindly your losses, I have taken your losses rule 12, sub-rule 2 and 3, verification of documents. After verification, interview list was prepared. What the commission did at that point of time, if I put a question to myself, this is the reassessment carried out after the interview in respect of 1463 candidates. Alleged reassessment. Now, if the verification was done properly, he could have given me a notice. Look, this is the thing. What do you want to say? And that in regard to your documents maintained by you. And no names were published, even today, if I am not wrong.
Yes.
Now, because I'm representing some of the candidates who are called for interview, but their names are not in the merit list because of this. I can anticipate.
Who are they?
I will take your lordships. I will. Specific instances I have given. Now,
that way it is very difficult to follow, Mr. Sannal. You make a chart to that effect.
I have. I will show to your loss. The written notes I have given your losses. Specific chart. But all the documents I do not have. I specifically said these names have not been disclosed by the commission.
Yes.
Then your losses will find 1460 ineligible candidates. The number of candidates goes below the statutory requirement of 1:1 in some of the categories, then the commission may call the required number of candidates for interview and pass in those categories if directed by the Honorable Court. Therefore, my lord, one thing is clear. As of today, the commission has not been able to maintain the ratio 1:1.4. Then how can there be a merit list, my lord? Because if some candidates further called upon, they could be in the higher position. They are on the persons who are already in the list, so-called merit list. You cannot guess it. And you are asking, allow me to appoint them.
Yes.
Then your lordships will find the last paragraphs, your lordships, 12, that the till date due to various reasons could not be concluded. The last selection process for the appointment of assistant teachers was the 12th regional selection test 2011, which was concluded in 2012. The panel which expired 2015. Since then, there has been no recommendation of the fresh upper primary teachers, for which all schools are suffering due to a severe draft of teacher of upper primary teachers. As a result of the long delay in concluding the upper primary, not only the successful can are suffering for want of employment, but also the students. But I can understand the students. But commission is vouching whose case, my lord?
Yes. Next, what do you say?
Then your losses, my lord, kindly come up to the other affidavits, the third affidavit, page 37 to 54. My lord, this was affirmed on, my lord, 20th April 2023. My lord, second page, internal page 2, running page 38, paragraph 3.
Yes.
My lord, see, my lord, paragraph 9 of the said affidavit. My lord, it starts with the expression. Paragraph 3. In paragraph 9 of the said affidavit, that means the last affidavit, it had also been stated that on further rechecking of the credentials of the candidates, irregularities were detected with regard to OMR seats of 1463 candidates. My lord, pause here for a moment. Is it the irregularity of the candidate or of the commission? You have given me mark sheet. This is not your allegation that I have quoted in my application form something contrary to your mark sheet. This is not your allegation. I am still holding my mark sheet. The irregularities included caste category mismatch of 2 candidates, mismatch of marks, 559 candidates, and defaced OMR seats, as well as mismatch of marks in respect of 902 candidates. In the said paragraph, it has also been pointed out that the total size of merit list was 12589. Then your losses, paragraph 4. I say that after affirming the said affidavit, the commission took up the task to analyze and recheck. But how many times, my lord? Again recheck the defaced OMR seats of 902 candidates more minutely. On rechecking, it was found. My lord, further reassessment, second time, then again third time rechecking. See what happened, your lordships. The defacement, a white mark, was mostly put in spaces provided in the OMR seat for bubbling the chosen option. That is A, B, C, or D in response to a particular question. Now, in case of a question where one of the options has been covered by a white mark and none of the other options have been shaded by the candidate, then presumption may be drawn that the candidate has marked the option which has been covered by the white mark, and he may be awarded marks accordingly, as it is not expected that a candidate who leave any answer unattempted when there is no negative marking. Everything in the basis of presumption, they are giving marks. The commission took up the task of re-evaluating such OMRs once again and checked whether such candidates would benefit if marks are awarded to them on the presumption that they had indeed chosen the option that the computer could not recognize due to defacement. My lord, entire work, your losses, I request your losses kindly bear in mind on the basis of scanned copies. If is confined only to 14,000, Total candidate of state, your loss is 2 lakhs and more. What is the case in regard to them? My lord, one will come up and say they are not before your lawsuit. That's not the point, your lawsuits, in writ jurisdiction. This is a public employment. You are dealing with the candidates.
Yes.
Then your losses 5. Upon rechecking the said defaced OMR seats in accordance with the aforesaid presumption, it appears that out of the said 902 candidates, there were 18 candidates who still had mismatch of marks. On comparing the marks of the rechecked OMR sheets with the marks in server of the commission, that puts them out of the zone of consideration. The remaining 8 to 1 candidates having defaced OMR seats after rechecking have come with the zone of consideration for being included in the merit list, in addition to the 1 to 589 candidates already referred to the previous affidavit. In addition to this, the commission will take up the task of rechecking the academic score and other candidate credentials like age, etc. of the candidates. Upon further rechecking of the academic score and other credentials of the said 13410 candidates, it appears that the 71 candidates are no longer within the zone of consideration for mismatch of their names, can no longer be included in the merit list. Hence, the total size of the merit list stands revised to 13339, and the total number of excluded candidates is now 713 instead of 1463. My lord, first they declared 1463 candidates, my lord. I'm now, therefore, your lordships, first they declared after interview 1463 candidates ineligible.
Please don't repeat, Mr. Sandal. We have taken note.
No, I'm trying to explain the situation, how it proceeds, your lordship.
We understand your anxiety. Please proceed. Otherwise,
Then your lordships. This is the third affidavit. Now I take your lordships. Kindly come, my lord, to my written notes of arguments.
this one finished. Anything else from
No, affidavit portion is finished. I will supplementary the given.
You want us to take up?
My lord, the written notes of arguments I handed up to your lordships. Not that one, your lordships, the other corrected copy of the list of dates and written notes.
This one?
Yes, your lordships.
Okay. Yes.
No, my lord, I have noted, my lord, it starts, I will not take your lordships to everything. This I have placed your lordships. Kindly come to page 9.
Yes. So you didn't oppose the prayer of the appeal court, that why you are allowing such a process to continue?
My lord, this disclosed after. That's why the court limited it. I argued it, your losses on the threshold, because I didn't know all these. How do I know it? They do not publish it anything. Even the interview list, according to rules, every details. They did not. I went before the court. That is the result of the appeal. The refusal. Then I came before the appeal court.
Refusal of what?
Go and make the governance redressal mechanism. In another matter, the same honorable judge published everything.
Public?
Everything. Then we came to know, and this was the order of the appeal bench. disclose everything materials. Then I came to know certain materials. I even didn't know who belonged to which category also. I am getting everything, rules is very clear, but they do not publish it. So therefore, it developed from time to time at the intervention of this honorable court.
Yes.
Submission page 9. I will just place my points I have noted. I have to place it before lawsuits.
You people were all there in the first selection process merit list.
No, everybody was. It's not. Some of them not. Because earlier election process cancelled 243 reasons. If you
So those persons who were there in the merit list, all the persons have excluded from the second merit list, the second process.
Not all. Not all. Some of them come, some of them ousted, some comes.
So if you don't allow them to make appointment, your clients are affected.
That's not the point.
Oh, that is not.
No, my point is your lawsuits
You do not want
sanctity of selection.
No, that is separate thing. Appeal court has have permitted the commission to go with the selection process.
Subject to the result.
So why you are making part of the clients your own enemies? They are suffering for this litigation.
No, I tell you lawsuits. The one thing, suffering only.
That is a broader argument you are making.
But
Mr.
that's I'm
Sharma.
making today.
We sort of wanted to know that allow a particular quantum in respect of whom there is no, what should I say? The scope is very limited to interfere with their appointment.
How could you say ascertain?
Let us complete. But in respect of the persons who were not included, if they have been illegally deprived, qua the persons who have been illegally inducted,
get your losses.
We have to weed out the illegal beneficiaries.
That's the point.
Then the entire process cannot.
I tell you losses.
No. Just consider this. Suppose you are having 50 clients. Out of them, say 30 have no problem. They will get the appointment if this is allowed. In respect of the 20 persons, qua 20 vacancies in which you could have got in, unless these illegalities would have been permitted, we will be insisting of that.
How could the losses determine it? Your losses, weeding out is a solution.
Out of the persons who were there in the merit list of the first selection process, which has been struck down, and the second selection process, which has initiated, though illegally, whatever illegality, some of your clients must have been featured in the.
This cannot be done, I tell you losses, because the entire result of take.
No, Mr. Sharnal, if you are saying that we all will keep quiet, we will not allow the process.
This is kindly do not.
So we are assisting you. We are saying that at least allow those persons who have already got.
How do you determine who are? Huh? How do you determine? That's the process I want to know, from your losses.
No.
Your losses, one solution. If X in both the panel, therefore he is clean. This is the solution. If X in
that
the
is one aspect. That is one aspect. Second is who have been, the zone of exclusion has to be within a quantifiable assumption. Suppose you have marks even upon, say, reassessment, whatever illegalities which you have pointed out. Maybe you are falling short of, say, 10 marks from the last selected candidates. But if you find that the candidate difference is more than 200 marks, then he will not come within the zone. Please appreciate. There is no possibility for such a. As in other litigations, what do you do, Mr. Sharna? That all right.
In other litigation, I don't find these sort of illegalities normally.
No, we are not.
This is manipulation of the.
We are saying that we want the persons who have been genuinely coming within the scope. Let them get appointment.
I tell you lawsuits. I have placed the Weimar seats situation.
We are not being, if you don't want to do that, then you give the data to us. Let us consider.
Data means which data,
Data means suppose Suppose you are falling short, you are dealing with the matter for so many days. We are taking up the matter for 2 days.
I tell you, Lordship.
We are learning from you that whatever facts you are arguing, we want to see that suppose 10 contestants are there, you find pursuant to your evaluation, the 2 will get appointment, that both who have found the place. Suppose there may be 2 candidates who will come within the zone of consideration, and there may be 5 candidates, even if even without setting aside the selection process, they will never get the appointment. If the range is so high, for that you can argue before us that how we can devise a plan to that effect.
We do not have the data. First, your Lordship, understand that. We must have the data first.
What data you want, tell us?
The data, all the marks, the category, everything.
Why of all the we want to, if you want to ascertain how much marks you got, that we can ascertain from the commission.
What about the candidates who in the list? I should not know.
All right then.
That's
All
the
right,
point.
Yes.
In our case, in the first selection, all we were there. But in the second selection, some have been eliminated, they have become unsuccessful, some have been successful.
That you have just now told us.
That's right. What your lordships are asking the questions, queries, that is also initially when we became a...
No, we are suggesting it is for you people to assist us. Because we have heard your argument for 1 day, Mr. Sun.
My lord, I tell your losses 2 things. The points involved here.
Points involved with
I tell you,
out of your, suppose you are representing 50 persons.
My lord, I get your losses when I bow down. Now, if your loss is my first point, if your losses holds in my favor, the entire thing should go. Why should your losses exercise that? Reservation point. If the first point your losses hold in my favor, the entire thing should go. Now, the Tate, I tell your losses. Take the manipulation, the scale of manipulation.
What happens to your persons who were...
My lord, this is not the point now. Your losses has...
We are asking you. No?
Well, the persons may go, may come.
All right.
May go, may come.
All right.
Now your losses state. I take your losses to this. Either
that argument we understand, you want the entire selection.
No, but I tell you, loss. Entire selection, one thing, my lord. If the entire thing is tainted by something which cannot be cured, my lord, Tate, there are 2 options open, my lord, according to my little knowledge. Either you cancel the entire Tate 2015, or whatever mark sheets you have given, you have to follow that. The 2 options. You cannot, in the name of reassessment, change my mark sheet.
All right. Yes, Mr. Sanan. Next.
Malad, kindly see the submissions in relate to page 9. 1. Re-evaluation, reassess.
Yes, Mr.
No. Now your losses kindly see. Re-evaluation, reassessment, scrutiny of the OMS.
Where you are going?
Malad, page 9.
Of the
written notes of arguments.
You have placed that?
No.
Yesterday?
No, that's in the reservation, my lord. Reservation and vacancy, my lord.
Yes.
Now, kindly see submissions. Re-evaluation, reassessment or scrutiny of OMRs only of the interviewed candidates by the commission at the time of selection process is illegal, unauthorized, arbitrary, unjustified, violative and contrary to the paragraph submission Roman 1, page 9.
Page 9. Oh. Yes, page 9.
Re-evaluation, reassessment or scrutiny of OMRs of the interviewed candidates by the commission at the time of selection process is illegal, unauthorized, arbitrary, unjustified, violative and contrary to the judgment of the Honorable Justice Bhattacharya and the judgment dated of the Honorable Division Bench and first provided to the Rule 1311 of the rules as well as Clause 11 of the brochure published by the Commission prohibiting re-evaluation of review of the OMRC. Now A. Re-evaluation or reassessment is permissible only on the application of the candidate. But I have not applied for reassessment. But Rule 1311 of the rules prohibits reassessment of OMR seats. Clause 11 information which will also put such prohibition. No application by the candidates in the interview list for reassessment. No notice given to the candidates prior to such reassessment. Purported re-evaluation of reassessment, if any, carried out after 8 years. Original OMR sheets not available. Purported re-evaluation or reassessment done on the scanned copies of the original OMR sheets. This raises a serious doubt about the correctness of such evaluation. Not scanned copies is a secondary evidence. Now, in the absence of original OMR sheet resulting published 8 years before such will be treated and final and conclusive. Then you'll also next page. Even in cases of alleged defacing OMR sheets, presumption in favor of candidate has been drawn by the commission by reconsidering the same. Reassessment OMR sheets of TET deprives the candidates of consideration of TET 2011 results of the candidate. That's another point. And commission is stopped from doing re-evaluation of the judgment of the TET in view of the judgment of Justice Bhattacharya. And the cases of reassessment of re-evaluation of OMR sheets results after completion of all eligible candidates is false first and contrary to affidavit of 30th October 2020.
So this reassessment was done when the appeal court heard the matter and allowed the process to continue, or that was not within your, it must have been within.
During the pendency of this appeal. This has been done during the pendency of this appeal.
No, prior thereto also they did, which was
They
held
did
to be
Justice
back.
Bhattacharya.
Yes.
That I do not know what's the fate. That's my point. How many times the TET answer sheet can be put to reassessment? How many times, my lord? It takes us to what situation, my lord?
Yes.
Then, my lord, the chart showing. Now your losses, kindly see the result of it. I will take your losses to 2 seats, your losses. My lord, kindly come to page 17.
17.
17.
You do not paging. Oh.
Pagination.
Yes, done. Sorry. Yes.
Malad, this is the difference I'm showing. Malad, kindly see the heading, difference with Aditi Roy. Malad, this candidate, Aditi Roy, Malad, is an English subject. Malad, she was called for interview the second time after the order of this honorable court. She was called for interview.
She was in the earlier merit list also.
Just a thing. Yes, she was. Now your lawsuits, she appeared at the interview. Interview list carried her name. She appeared at the interview. After the interview, in the merit list, she didn't find her name. Therefore, she comes within the 1460 candidates. Obviously, there are because she was in the interview list second time, but her name was not. Malad, she comes within the, we assume, because this is not disclosed even. Even today, I do not know where I am, for what reason. Kindly see your losses, the marks secured by her. Malad, your losses, the middle portion, Aditi Roy. Madhyamik Parikha 10, HS 10, graduation 18, training 10, TET weightage 34.13. Malad, this has been assessed by her. And on this basis, she was called for interview. That's the mark sheet given by the commission. Mark sheet given by the commission. E-mark sheet. She is still holding that. And your losses, total score before interview 82.13. Your losses clear? Now kindly see your losses. Any of the name your losses will find.
Personality is 10 marks. Huh?
Personality 10 marks. Now your losses, the first candidate, Madhurima Bishwas. Kindly see her Narane Baba bolchi to. Well, kindly see total score before interview Madhurima 84.4 above her. And he panel the highest candidate, topmost candidate. Now kindly see in the candidate your losses, third name, Shatabdi Paramanik. Well, total score before interview below Aditi. Kindly see 79 point something. Now, she is the panel lowest candidate because she was called for interview. I was also called for interview, but I have not been given any marks, probably because of mismatch of marks with the server and the scan copy. I am not sure what has happened to me.
Server means?
Server means the commission server. Well, suppose probably I will take to their written notes. Server shows your lordship.
It's your TET certificate marks.
That no, not even. I am having a
Then mismatch of which mark?
mismatch. That's I'm saying. Scan copy. According to scan copy, there is a mark on the OMR sheet. Scan copy of the OMR sheet.
State OMR.
State OMR.
2015.
2015. And server copy means server means
OMR scans copy. There was a certain mark.
Marks. And their server shows different marks. Obviously, that will be lower than the scan copy. But I do not.
Why do you say so? Lower
That's
than
they say. Otherwise, there can mismatch. It may be higher also. Since their records do not tally with each other. And scan copy. Kindly lordships consider that. I do not have the, if I want to see, show me my original. I do not have it. And they do not disclose it.
Did they scan it? Then where from did they scan it?
I do not know. From the, according to them, my lord, would be original.
So if the original is not there, how there can be scanning?
My lord, original was there. Probably they have destroyed after scanning. They are the best persons to say to your lordships. They have not disclosed. I did not at least find. I will stand corrected if they have disclosed. Obviously, the result of destruction. After keeping the scan copy, they have destroyed the original. Now, these things now appears. Yes. Then what will happen to the situation? Therefore, my lord, audit is deprived because of this. Now, see the next one, your lordships. My lord, one more, your lordships.
So in respect of Madhurima, there was no such mismatch. So she was considered.
Yes. My lord, I tell your lordships, how could you lordships believe there was no mismatch? How can I believe the commission if they favor Madhurima? How should I believe them? After all this, you have given me marks. Now you can aspire me, my lord, allege against me that you have done something with some officials. Then your officials are culprit.
What happens to the fate of the candidates? Today, next selection process, they will again proceed in the same manner.
Then your
Same
lordship,
defacement.
I tell you lordships.
Then what is the remedy? We have to change the law.
No, I tell you lordships. No, I get it.
Suggestion, you have to tell us what we will do.
Change the law means I couldn't get your lordships.
That means the state procedure, something we have to say something, put some strict, put some restrictions that this original certificate, because they say what are their grounds, as you have pointed out, that when the appeal was proceeding, they have conducted mismatch on any particular excuse. They have deprived some candidates. That is why you are aggrieved. Today, suppose the selection process is cancelled. On what basis they will proceed?
No,
and
I
how
tell you,
many restrictions?
I tell you lordships, your lordships, if your lordships not only selection, now your lordship has to go into the correctness of the TET 2015 also.
Exactly.
Do that.
Yes.
Do that. Do that. Your lordship has to go. I'm conscious of this, my lord. Either it will, that's why I say either cancel entire TET 2015 or let them act according to the OMRC mark sheet given to us. Two options open to them. They cannot proceed on the basis of the scanned copies. This is not the evidence, admissible evidence. Well, then 65B will come in. All things will go. The candidates.
Then
also.
what they will do?
Reassessment stage.
Reassessment which stage? Tell us.
Assessment?
Reassessment. You have been given the EO.
Can there be any reassessment of the OMR sheet by the commission itself?
Argument is that they cannot do it.
They cannot do it.
Now they have done it. Wrong has been committed.
Well,
Election process.
That's the solution. If this is the scale of manipulation or illegalities, then either it should go all lock, stock and barrel, or you proceed on the basis of the mark sheet you have given. You cannot, I am holding a mark sheet. You cannot say my mark sheet is bad.
No, you have been given OMR mark sheets.
E-mark sheets.
Of the TET.
TET.
Now, in your case, how they have reassessed that also? No. Let us understand.
Yes.
They have reassessed it on the basis of scanned
copies. I will take their submissions, your lordships. I will take. I am saying it. Your lordships should get the exact language they have used.
Now, all of your candidates, petitioner, respondent, all have EOMR TET results?
Yes. Now, suppose you have Rajiv Bommo. I tell you, lordship, an example. He is not in the interview list. He is short of 1 marks. I have taken his name for the argument of reservation. Now, he is holding the mark sheet. Now, suppose your lordship holds the reservation point in my favor. Then he will certainly come up in the interview list. Then again come up and say, you do not serve a mismatch. But what sort of commission, my lord, is this? You have made a mess of it. You have made a mess of it. I am not the you are the culprit. Statute has invested the power with you to do certain thing honestly. You are dishonest. And I have to suffer for that, my lord. But that's why I oppose the payment. Your losses cannot wait out. I am aware of the Supreme Court judgment. This can limit it to out of 1,000 candidates, 2, 3, 5, 6, 7, 8, 9. Your losses can extend it to 100, but it goes to all. The principle evolved by the Supreme Court.
If you say that proceed on the basis of OMR of the
candidates given,
candidates mark sheet given, then this OMR cannot be reassessed. This reassessment portion, it has to go.
Absolutely.
Reassessment.
So does that solve your problem?
I tell you, losses.
No, tell us, does that solve your problem?
Malad, it's not a question of solving my problem. Probably, Malad, your losses is going to the inter-C fight. I am not on the inter-C fight right now. It may one of my mind.
Later you will come to that.
Malad,
Later you will come to that.
Malad, I'm trying to, Malad, but this is the situation your losses is dealing with.
How we can remedy the issue
Malad,
so that the majority, so that we are anxious about this.
Malad, my submission,
anxious about the
Malad, my submission is that it's up to your lordships to accept or not. My submission that proceed on the basis of EMR's mark sheets given to all.
Then
this has two difficulty. I tell your lordships. I have thought of it.
Yes.
Then your lordship permitting the illegality to remain as it is.
Yes.
This one. The other thing, your lordships, this is the result. The other thing, your lordships, would be the permitting this illegality which has now surfaced on their affidavit. The resultant effect would be whatever it be, but that e-mark sheets.
No.
This will save the situation at least.
EOMR mark sheets, if we ask them to proceed on the basis of this EOMR mark sheet, does it solve the problem?
I tell you, losses.
Because you have other grounds of challenge also.
No, that's not. Reservation, your loss is different. That's your loss. That remains.
Then what
that
is
remains.
the utility?
No, I tell you, one thing is solved. One thing is solved. One thing solved. If your losses direct them, accept the e-mark sheets, then that dispute is at least settled.
No, we will not do it in a half-hearted manner. We have to do it.
No,
fully.
then they can proceed afresh on the e-mark sheet from if your losses hold the reservation point from the stage of the interview list preparation.
No.
That I can submit your losses to this
stage of the
interview list, because if your losses holds the two things. If your losses,
so your reservation comes at that time.
I'm coming to that. But if your losses hold, commission is directed, no reassessment will be allowed. This is wrong exercise. You proceed on the mark sheets given, you have already given to the candidates. Then if your losses holds that the reservation point in my favor, then interview list goes. From that your losses, the interview list preparation, they will again proceed at a certain time frame.
Category wise.
Category. That your losses. That's my I have thought.
Then in the interview list,
Interview list,
again
there
this
would be
placement in
category wise means reservation will be applied.
Reservation will be applied at the time of recommendation.
At the time of
Panel.
of interview list.
Not interview. That's my point.
We shall see.
That's your loss. It's a constitutional point. I will try to impress upon laws if this is the law, not other way around. But one language is now being used in this level playing field. Level playing field only comes after the conclusion of the interview or personality test, not before that.
Yes, proceed, Mr. Shan.
Normally, your losses kindly come to page 18.
You finish your arguments, your suggestion we have taken note of. Yes. Page
18. But I'm showing whatever the documents I have been able to collect.
Yes.
This is the Aditi Rai candidature, your losses in relates to English subject. Now this is geography.
Same thing has happened.
Same thing has happened. The difference will be your losses.
We appreciate. Now you come to your next point. You have showed us as an illustration the mark sheets. Yes.
Now your losses, kindly see their commission's affidavit on this point, only paragraphs.
Just now you showed us. No, you said I have finished.
No, this is their affidavit. Commission's
affidavit.
I have seen commission's affidavit. Written notes of arguments.
Oh,
because this they have dealt with mismatch. Affidavits are cryptic affidavit, my lord.
No, you said affidavit.
I'm sorry, my lord. The expression I have wrong.
Not our fault.
No, my lord.
Yes.
No, my lord, your losses will be getting it. My lord, their pagination at the bottom, 2. My lord, reassessment of tape marks. Clause number 6. The appellants have argued that the reassessment of tape marks is not permitted under the 2016 rules.
Clause 6. That is page.
Reassessment of tape marks. The appellants have argued that the reassessment of tape marks is not permitted under the Rule 2016 rules or by virtue of the judgment of the learned single judge or under the rules governing the conduct of SLST. All that your lordships. I'm giving the 3-4 names there. Now 7 your lordships. It is respectfully submitted that said argument cannot be accepted in the facts and circumstances of the case. The judgment that the learned single judge permitted commission to carry out the selection process from this rule of 12.3. If I'm not wrong, that should be rule 12.2.
2 onwards.
2 onwards.
3
Now, then rule 12.3 explicitly permits commission to verify the validity of the TET certificate. Malad validity, I have submitted. Validity means initially it was valid for 3 years, then it was made 7 years. Now it is for time, all the time to come.
For TET 12 and 16 both.
Like
Yes.
and the marks obtained in TET. Kindly see, Malad, there is a clutch. Malad 12.3 permits the commission to verify the marks obtained in TET. They are trying to, Malad.
That is not there.
That's there. Verify. Your lordship's language
Why
there,
is
that's
there?
not there they use in a sense that is not. I will take your lordship's rule 12.3. Then rechecking of TET marks was done in order to maintain the sanctity and purity of the selection process. Well, pause there for a moment. Sanctity, you have done the given the marks, and you are doing your sanctity and purity.
TET was conducted
By the commission.
School Service
School Service Commission. And they are now doing their sanctity and purity, everything. To safeguard against possible discrepancies in the computation of marks that have been awarded. Kindly see your losses.
Yes.
And the marks which are on the records of the commission. First reasoning. Second, first provision to Rule 13 of the 2016 rules is not attracted in the instant case. It is not the case. I am not on that. No prejudice can be claimed to be caused to any candidate, since the instant rechecking is not akin to giving candidates a second chance at improving their scores for the purpose. But I fail to understand this. I have been given 70 marks. On rechecking, you
There
say
may be reduction also. Yes.
Then not only reduction, your lordships. The other point kindly consider. Then suppose one X in the mark sheet have got lesser marks than me. On rechecking, he crosses my marks. That affects me.
Yes, yes.
Because of this illegal reassessment.
Hmm.
You may have some favored candidates. You have assessed them and get it higher marks.
Yes.
Then your lordship, the objection based on clause C information, it is submitted that there is no allegation. This correction had deprived anyone of the opportunity to exercise particular options between TET 11 and 2015. They now say, your lordships.
This clause 6, this information brochure is where?
This is in part of the process. Notes. Yes.
In this, which one? This one?
I think I just give you.
This one.
This one.
Oh, ঠিক আছে. Yes.
G. Rather, it seeks to correct mistakes which may have crept into the records of the commission, and to ensure that the candidates who are ultimately recommended have the requisite qualifications.
But that is separate aspect.
No, separate aspect. Your losses kindly see. This is in regard to reassessment. They say that this seeks to correct mistakes which may have crept into the records of the commission. Suppose my marks have been wrongly recorded in the mark sheet, but the record says something else. That's they're trying to say. And to ensure that the candidates who are ultimately recommended have the requisite. Now they correct their mistake and say he is eligible or he is not eligible.
Yes.
Then H, the statistics pertaining to such a correction process that was under is already tabulated. Here is also part of the supplementary affidavit. No. There is no direction of the Honorable Court in the order dated to the effect that the mistakes which have crept in the records of the West Commission in respect of TET qualification and marks obtained could not be corrected, and particularly such correction was not a reassessment. Well, they are now trying to improve their affidavit. Kindly have a look at this. All throughout, right from the Justice Bhattacharya's proceedings, they have said they have reassessed, re-evaluated. Now they say there is a correction, mistaken marks in of the TET marks 2015. Now J, on 27th March 23 and 20th April supplementary were filed by the indicating the steps it is proposing to take correct mistakes. Now they are trying to make up their affidavit now. This is not the language they use.
Yes.
They have kept into the records of the commission with regard to the marks obtained in TET.
Anything else, Mr.
Now,
Sharma?
this is the lordships. So far the marks is concerned.
Yes.
Now,
Manipulation, subject one. Next.
Now your lordships, just
Yes, Mr. Sharma.
Now your losses kindly take up the point. I have pen the judgments I will be citing. I have taken the point of
Same judgments which you referred before Justice Bhattacharya.
no. The facts are totally different now here, your losses.
Yes.
Justice Bhattacharya.
Yes.
Now your losses so far Justice before Justice Bhattacharya, they so for reservation point they proceeded category wise, and there was no such case at all. Here, my lord, this has come up for the first time in the second process.
In that it was
category wise.
Category wise at the time of interview list.
Interview list.
Which you are saying could not have been done.
Now, your losses, they have not done categories. They have migration they have done. Earlier stage, they didn't allow any migration. That means, on the basis of merit, scheduled caste candidate in the interview list was not brought in the vacancies of general category. This was not done by them.
No, you just you place that
You just place. Yes.
I
Table.
Now, that chart your losses will be getting at page 24.
এরিয়াটা কোথায় গেল সেটা না this is at the cost of our repetition.
No,
not
you
your
lost
page
24.
দেখছিলাম তো না এইটা Now you said 12-4, they have to do it category wise. So what did they do?
I tell you losses.
Just repeat.
Just repeat. Your losses. They do category wise on the basis of merit. Your losses, see the language.
Shall prepare and publish website the interview list with all details of the candidates we call for personal test category wise on the basis of merit.
Category wise define your losses in subsection 2.
Rule 2A.
See what the problem. Just a minute. That defines your losses.
Category wise separate category for
subject category, medium category, reservation category. We are concerned with reservation category. Reservation category, your losses have been defined. Your losses in J. First category defined, then reservation category. Reservation category means scheduled caste, scheduled tribes, other backward classes. And physically handicapped.
Yes.
My clear submission before losses in the reservation category, this reservation category will end category definition had to be read with rule 12.4. If we read with 12.4, scheduled caste candidates to be first categorized, scheduled tribe, OBCA, OBCB. So for general category, general vacancies or unreserved vacancies or open category, this is their case. If a scheduled caste candidate on the basis of merit goes to open category, there is no bar. Clear to losses?
Yes.
This I am taking exception at the interview stage. Because this is not the final selection. Law.
How you are prejudiced?
Because
there are total 1,000 candidates, 1,000 vacancies.
Yes.
You will be calling 1:1.4. That is say 1,100 vacancies.
14,000. This will be 14.
Sorry, 14. Yes. 14. Now this is the total number of vacancies. Now you are saying that now what they are doing?
They are doing first year losses out of this 14,000. According to reservation percentage, they have to keep aside the scheduled caste category vacancies.
Yes.
We have
Yes,
to call
yes.
out 1:1.
They will do so.
Scheduled tribe.
So here they keep out vacancies for the respective categories. Unreserved, SC, ST, OBCA, OBCB.
After, my lord, allowing on merit these reserved category candidates to be migrated in the general category, then the rest they have done. Clear to your losses? I'm ogin loss. Suppose, my lord, I'm reserved category candidate. I got 10 marks. My learned friend scheduled caste category. He got 11 marks. He have straightway brought to the open category.
That we have understood. Subject.
That's the point.
We are
I'm questioning.
No, then suppose you are brought in a general category. You have the person, you secured general category 10 marks. And an SC candidate had secured 11 marks. He is brought to the general category because he can compete with the general category candidates.
These principles, my lord, will be applied at this time of...
No. Then what happens to the other principle that even if he is appointed through the general category, your quota in SC will remain?
That remain. Resultant effect, they did not get the candidature. I have given to your losses other chart, your losses.
No, Mr. Sannal, actually, most probably, they, in respect of 1,000 vacancies, they will call 1400. Now, if they started calling candidate from top to, from 1 to 14, then they call. Then they started taking interview. Now, if situation arises that they will not get any scheduled caste candidate,
then I tell you losses.
So before calling interview, they will categorize. Open, I have got 10 vacancy, so I shall call 14. Open is open to all. So first 14 candidate you go to
scheduled caste.
Then I am to call 10 vacancy SC. That is, I am to call 14 candidate. Then I shall start finding out SC candidate. Then when I shall get 14 candidate, I shall fill up. Then I SC, OBC. In this way. Otherwise, if I call first 1400 candidate, then it will appear that I am not getting any OBC B. I am not getting any OBC A.
No.
Then I shall not be able to complete the...
No. Malad, this not the Malad, as I understand the law. Yes. Malad, 14,000 vacancies. Malad, 14,000 vacancies. There will not be 50% above reservation. It will confine to 50%. Malad, suppose general vacancies comes to by open category, whatever language you use, Malad. General, unreserved, open. Malad, this comes to suppose 600.
That is considering 100-point roster. They have fixed that when the vacancy is 1400, then how many posts will be for open, how many posts will be ST. This has already been fixed, applying the 100-point roster. When vacancy statement prepared, we have got some experience. Actually, we are undertaking some delays. When we have got vacancy statement, then we have already prepared that 100-point roster we have applied. Then we shall get general candidate of 10, SC candidate 3, ST candidate 4. Then we have already prepared it. Then they will call, I shall get 10 open candidate, then I shall call 14. It is open to all, first 14 candidate you go. In this way they will categorize. Otherwise, if they call the first 1400 candidates, you come.
I tell you losses.
Are you clear?
I am clear.
But from first 1400, there is no ST candidate. First 1400, there is no physical handicap candidate. Then how I shall fill up that post?
Well, I tell you losses. Here, well, this is one of the situation your losses. Well, now, I tell you losses. They will call for on the basis of merit.
Yes.
Merit. Now your losses, one way, according to the rule, category wise.
No, we understand. We are saying merit. What my brother is saying, suppose 1400 vacancies. Out of that, general category will be say 700 candidates. SC will be say 100. ST will be say 98. This separation they are making Then on the basis of the merit, they are filling up those respective quota. Suppose their SC is 5, then they will have to call 5 into 1.4 number of candidates.
That's permissible.
Then what is the problem you are facing?
That's my
You are saying that you are arguing a point of law. We are on the count of prejudice. Arguing a point of law that you could not have applied there. Good, bad, indifferent, maybe your submission is worthy of consideration. But we are considering the question of prejudice. How you are explaining.
That's your losses I'm showing to your losses.
Yes, please tell us.
I gave an example. May I take that example again?
Yes, again.
Rajiv Brahmo. I have given your losses.
Yes.
He is a general category candidate. I will take your losses to that. The other chart. I have
General category candidate.
General category candidate. He short of 1.1 or something marks of the last candidate.
One interruption, Mr. Sandal. Suppose there are
general candidate.
Last general candidate.
But your losses.
10, 14.
I tell you losses. This candidate list already includes other reserve category candidates. General category vacancies. Therefore, my lord, I am short of the last candidate 1:1.4. If those candidates are not brought in,
Excuse repetition, other candidate. No, it is open to all.
This is applied at the time of preparation of
It is
panel.
called you are undeserved. It is open to all.
Malad, I tell you
It
losses.
is not ladies seat. It is seat for all.
No, Malad, I get that. That's my argument, your losses, that this cannot be done in the interview stage. This should be done at the appointment panel or recommendation stage. Then your losses, you are doing it before participation of interview. My selection is not complete.
Okay, if I try to give you another reason that at the time of calling the candidates for the open candidate, open category, I shall not see whether such person is SC or ST or OBC. No. Open according to marks.
Open language should not be used at the time of interview list. It becomes open only at the time of recommendation or preparation of panel.
All right.
It is not before that open to all.
So you are saying Rajiv Brahmo was the last candidate, say 14. He could not come since above them some reserved category candidates were inducted. This
is an example. And that's admitted your losses in the chart I have given to your losses.
Yes, where is Mr. Bhattacharya now? You have finished.
No, the judgment I am showing to your losses.
Please call Mr. Bhattacharya, whoever is here. Yes.
Mr.
Sannal, you can give us that what are the judgments?
Yes.
That list if you can give. And you want to place any particular judgment? Or
Yes,
you can give
I want to. On the proposition, I want to.
Please proceed, Mr.
Judgment, copy আছে না? হ্যাঁ? আচ্ছা জজ সাহেবদেরকে সব কপি দেওয়া হয়েছিল একটা দেখুন তো
জজ সাহেব পরিবর্তন হয়ে গেছে জজ সাহেব
না আমার কপি আগের বার মালা দেওয়া হয়েছিল অল কপি
আমরা জানি না we are new people we want new judgment Mr. Sannal
I think আচ্ছা আমি যে কালকে তোদেরকে দিলাম জেরক্স করলি সেটা কই
There is another.
ও দেখো কি বলছে আছে কিনা did you give any compilation like this?
No, Malad, I don't. Malad, your losses, Malad, take note of the paragraphs on the judgment.
That will be the best way. Give us the citation and paragraphs. তুমিও লিখে নাও কার্তিক তুমিও লেখো যাতে ওই খুঁজে বের করতে পারো
Yes. Malad, the first judgment, your losses, both of us probably cited on the earlier occasion. Malad, India Sani's judgment.
Acha.
1992.
Give us the paragraph.
I am giving a losses. 1992, supplementary volume 3, page 217, paragraph 812.
এই একটু তুমি লিখে নাও না এটা প্যারাগ্রাফ
812
এইটা নিয়ে না একটা লিস্ট তৈরি করে দিয়ে দিও তো very good 1992 supplement 3217
page 217
page paragraph
812
then
Then your lordships, 2010, volume 7 SCC.
2010.
10, volume 7 SCC, page 234. দুটো copy আছে?
234.
234. Matlab, that one very longish judgment we could not photocopy it. This I am the photocopies. Kindly allow me to place it, your lordship.
Interest on is not very much pages.
No, not interest on this judgment.
এতটুকুন এই মোটা 13 জন জজ
My kindly your lordships, whatever judgment shown to your lordships by all of us, and my humble request to your lordships kindly consider that this open theory, level playing field, my lord, the migration of the scheduled caste candidate to the open category, all either at the stage of preparation of panel or recommendation or appointment, not at the initial stage of recruitment or curtailment, before selection is completed. None of the judgments. Here is one of the judgment. This is constitutional judgment. I am trying to impress upon your losses. Kindly see. Kindly consider paragraph 3. A 3-judge bench of this court, by order dated 4, refer these cases to the Constitution bench, as it raises an important legal question as to whether candidates belong to reserved category who get recommended against general and unreserved vacancies. Kindly see, who get recommended against general or unreserved on account of their merit without the benefit of any relaxation or concession, can opt for a higher choice of service earmark for the reserved category and thereby migrate to reserved category.
Yes.
Well, this is your losses. Therefore, kindly consider rules. I will take your losses. This allows only at the time of recommendation. After the entire selection process is completed, whosoever comes, then your losses, this sorting is done out. Then paragraph 9. But I will just here the rules. Kindly consider this. Rule 16 lays down the manner of selection, preparation of merit list, and selection of candidates.
Paragraph?
Paragraph 9. Your lordships, at page 240. Online printing, this is the difficulty. At the bottom, your lordships will find paragraph 9. Rule 16 lays down the manner of selection, preparation of merit list, and selection of candidates. The said rule is extracted below. After interview, the candidates will be arranged by the commission in order of merit. Pause here for a moment. Justice Chakraborty, your lordships referring to before interview. Kindly see after interview.
Yes,
After interview, the candidate. I am not opposing after interview. I am opposing before interview. In the order of merit as disclosed by the aggregate marks finally awarded to each candidate in the main examination. Thereafter, the commission shall, for the purpose of recommending candidates against unreserved vacancy, fix a qualifying mark with reference to the number of unreserved vacancies to be filled up on the basis of the main examination. For the purpose of recommending reserved category candidates belonging to the scheduled caste, scheduled type, the commission may relax. That's another aspect. Therefore, your losses, this rule stipulates the condition that complete the entire selection. Then you consider according to merit who one goes to where. Before completion, you cannot. Then your losses, I am not taking your losses to proviso. 2. While making service allocation, the candidates belonging to the scheduled caste, scheduled types, or other backward classes recommended against unreserved vacancies may be adjusted against reserved vacancies by the government if by this process they get a service of higher choice in order of their preference.
Very good. Your proposition is at the time of recommendation it can be done.
Recommendation or preparation of panel, not your losses before that.
At that time also it would be migration will be done.
Which time?
Kindly example, one person has got, whom I call as open candidate, he has got 5. While SC candidate, after interview is held, got 7.
then he would be appointed as OP.
That's permissible, my lord.
As migration at the time of giving appointment will be done. But at the time of calling the candidate for interview, then category wise they have be.
That has to be done. That is not done here.
Yeah.
Their migration was allowed at the time of interview.
না তাতে ধর তিনটে মেরিটোরিয়াস ক্যান্ডিডেট তাহলে যে 14 নম্বরে ছিল সে তো আর বেরোতে পারবে না। ও বলছে ওটা তুমি করবে at the time of না আমরা কনসিডার
But your losses kindly page 23, kindly remember your losses of the written notes, kindly take note of that because that's my main thought.
Yes, that you have argued.
Page 23.
Yes.
The resultant effect. How many candidates have been brought in the general category at the time of interview?
Yes.
Before the interview?
Yes, next.
More than 50%.
Which judgment? Next judgment?
Next judgment, I tell you losses. Next judgment, 2015, volume 13 SCC.
Same point?
No, this is a different point. Page 722. Paragraphs 11 to 14.
This is on the issue of?
I tell you, this is what rule says that has to be followed.
You cannot act beyond the rule.
Beyond the, why I'm
a statutory authority has to act on.
Why it should be applied, I tell you now.
Yes.
Your losses was completely against me. I get an impression in regard to vacancy that I'm trying to eating out everybody.
No, we didn't say that we are.
The first impression I get it, Malad. Anyway, I have to deal with the situation. Now, Malad, 16 advertisement. 19 was the first starting of the selection process. 3 years. This is not fault of the candidates. This is also, according to me, not so relevant. The relevant parties, rule says advertised vacancy are tentative. Rule says, they say before calling for the interview, before 15 days, you publish final vacancies. That means, suppose your losses, this deals with my zone of consideration vis-a-vis vacancies. Suppose on the tentative vacancies, I do not come on the basis of my merit. But before 15 days of interview, the vacancy increases, I can come within the zone of consideration. This is being taken away by the commission because in between this, those two vacancies, page 30 and 32 are old.
Yes.
Number, your losses do not go by the numbers. I'm on the law only simply. Yes. Because creation of new post also comes within the clutches of definition of vacancy.
Yes, existing expectation.
It's not that. But I'm conscious of the law. Conscious of the law, the authorities cannot proceed against the declared vacancies. They cannot exceed the declared vacancies. But each case is dependent upon the rules. Here rules permit. Because the first one says tentative. This is not final. You make it final here. Why, my lord? Because of the provisions of the Right to Education Act. If you allow me to elaborate, I can elaborate. This is because of the right, because every time's pupil-teacher ratio, my lord, differs. Today is one, tomorrow is other. The authorities must keep a panel alive for that, so that they can require from the panel, they can send someone. This is because this rule is somewhat different from the normal rules found in the service jurisprudence. So therefore, the rule says it. I'm not asking something to do your lawsuits which do not rule say. I'm saying stick to your rule.
Yes.
Then your lawsuits 2005, volume 5 SCC, page 598, page 62. Because here I am saying commission bound by its advertisement.
Para 62 or page 62?
Para 62.
These are two judgments on the same line.
No, there I tell you losses. Commission is bound by advertisement.
Oh, bound by advertisement.
The commission here, my lord, in the advertisement itself, your lordships will get it here, this bunch, the advertisement. This is tentative. If your lordships, advertisement,
yes, that has been stated in the That is all right, we understand.
But just one page, page 19 of this month.
Yes.
Page 19. This is the advertisement. Kindly see clause 8. Vacancy position 1030. Kindly see published in WBSC official website with notification. Kindly see the nota bene just below. The detailed subject-wise vacancies are available in separate sheet in our official website. Final vacancies may increase due to creation of new vacancies, and vacancies may decrease due to general transfer. So, this is the clause according to the rules.
Yes.
Commission cannot deviate. There is creation of post before final vacancy list published. You have to include it. This will, make it horizontal.
Yes.
These are my submissions.
Thank you. Yes, Mr. Bhatt.
Mr. Sanyal has.
Mr. Bhatt, you are appearing in which appeal?
Yes, my juniors.
Yes, yes. Please give us.
দিয়ে দাও নাম নাম্বার গুলো দিয়ে দাও
কত নম্বরে
27 এ
আমার বিফটা কোথায়
স্যারের ব্রিফটা দাও স্যারের ওটা ব্রিফ নয়
I would not really repeat, try to avoid more repetition, but may refer Miller very important aspect of it. Now, first of all, a selection process was undertaken and which was declared to be illegal and set at naught by a court, and that has reached its finality. There was declaration about the process undertaken was thoroughly illegal, and then court directed that you proceed afresh. Now, while proceeding afresh, if you repeat the same mistake and repeat it in a grievous further manipulation, initially we did not and we could not allege any other malice in it, but after the affidavit filed before your lordship in the proceedings, that I would allege, yes, the corruption was also kept in while the new process was undertaken. Yes. Now, these are the tried submission before the division bench that the authorities created under the Act and Statute, they have to strictly comply with that. And the learned single judge, which was upheld by the division bench, said, follow de novo from a particular stage. You don't have to invite application. You don't have to wide open the scope for applicant. Those who were applicant, now you follow strictly 12-2 onwards. Well, I shall place 12-2 onwards without what are the relevance of it. So Mr. Sanyal has placed in detail, but I would also, I am really prompted to refer it. The kindly takes up the rules. Sir.
Yes.
Yes. The rules are a part of the.
Yes, yes, we have got it.
Yes. Now, I am not troubling my lord with the definition of category, reserve category, reservation. These are very preliminary things to follow. But the learned single judge found certain irregularities, was to set aside, then strictly follow 12. But this is very important. The Central Commission shall arrange for proper custody of all online applications which may be received by it against the vacancies. Then Central Commission, after receiving application forms, shall prepare list of eligible candidates. First shortlisting.
Yes.
Prepare list of eligible candidates for the purpose of preparation of a computer-generated database of all the candidates. Then 3, the Central Commission shall verify the validity of TET certificate, academic and professional qualification of the candidate having valid TET certificate, and marks obtained in TET and other academic and professional qualifications shall be evaluated in the manner mentioned in Part A of Schedule 2. Statute prescribes not the method of distribution of marks for evaluation. The Commission doesn't have any discretion whatsoever. They will only see whether the TET certificate given is a valid or it's a false one. Nothing more than that. Then next step. The Central Commission shall prepare and publish in their website an interview list with all details of the candidates to be called for personality test category-wise on the basis of merit as mentioned in Part A. Therefore, this merit should be category-wise. Then you have to call for interview category-wise. That is very important. And then after interview, the Central Commission shall, from interview list, prepare and publish a merit list category-wise on the basis of merit. And what are the merit? Weightage of TET and below academic and professional qualification. And they have to publish it. Out of the short list prepared on the basis of category-wise application. Then 6, Central Commission shall also prepare and publish in their website, the publication is a compulsory requirement, a panel of candidates category-wise equal to the number of vacancies and a category-wise waiting list for the rest of the candidates from merit list who were not included in the panel. One is the merit list for the purpose of appointment, because merit list who have vacancy, that they will get immediate appointment. Another merit list of the waiting list for any contingencies which arises from the merit panel 1, they can be upgraded from the waiting list. That is the purpose. Then provided that the Central Commission shall publish in their website the appropriate answers of the questions for general information. Now these I submit for the purpose of maintaining transparency, which is the basic requirement of Article 14. Now the Supreme Court has said, irrespective of the fact whether the rule prescribes or not, you are to publish everything for the sake of transparency in consonance with the principles of Article 14, which means non-arbitrariness. Then, but I am not reading out the second proviso. Then Central Commission shall publish such panel and waiting list of candidates in the websites of the Commission as well as the offices of the concerned regional commission. A copy of the same will be submitted to the School Education Department and Director of School Education for information. Well, this being the Millard specific requirement, which have not been followed. And kindly now turn to page 17. Advertisement. The eligibility, because the question was prepare a list of eligible candidates. Now, who are eligible? That is notified in the advertisement. Both trained and untrained candidates. Because untrained applications are also there, not? I shall argue on that.
Advertisement in that compilation.
Page 17, page 16. Page 16 of the compilation which Milo was looking at.
No, not your compilation.
No, no.
We are taking another.
Compilation of Mr. Sanyal, Rajiv Brahmo. That not, since he has referred, I am referring to that.
We have been given that.
That particular file.
Board file.
Notification. This one.
Yes.
Yes.
Yeah.
Kindly come to item 2. Eligible both trained and untrained candidates for first state level selection as per the minimum qualification laid down by the West Bengal School Service Commission rules 2016 and subsequent amendments may apply online only and for by no other mode, visiting the official websites of the West Bengal School Service Commission. What is the obligation of the eligible candidates? This is important. Must enclose passport size photograph, signature, mentioning region for personality test if called for. And academic qualification till date of submission of application for first SLST. And fill in the details required and make necessary payment. Can you forget about that? Then, III, candidates shall be called for personality tests in the region. Now, this is very important. Immediately, also get back to the definition of category and region. Therefore, the personality test should not be a one composite. It should be based on region of option given by you. Suppose I have given that I will be in Burdwan region. Will be called only for that Burdwan, not for Calcutta. Then shall call for personality test in the region where she had appeared TET examination. Subject-wise vacancies in each group shall be clearly mentioned. Candidates may choose his a subject group which he had in TET examination, and the subject chosen shall be in a subject in his graduation level. Kindly now turn over to the next page. The little bold millet, incomplete and wrong applications will be treated as cancelled. Then both the TET examination 11 and 15 conducted by the Central School Service Commission valid. Candidates may use any one for weightage of TET. Then kindly turn to manner of selection, my lord. I am not troubling, my lord.
So, do they have to exercise any option for
Yes.
choosing which state certificate they want?
Yes.
So a person who appeared in the first state and was successful, he will again appear in
He had
another
also
state.
appeared in 2015 test for better ranking.
I see.
For better ranking.
Thereafter, in the form, there is an option. Which
Yes.
one you want?
Now kindly turn to the next page. What is the TET weightage? TET weightage is 40 marks. Academic qualification and professional qualification 50. And personality test 10. This is total 100 marks on which a person will not contest, irrespective of his categorization, and reaches the stage of selection. Then the question of migration from SC/ST or any to general cadre would arise. That is argued. I am not troubling much with that. Then certificates of TET, note, 2011 or downloaded mark sheets of TET 2015 should be referred for filling up forms. Certificate of TET was given. That's why they say categorically certificate of TET, or since certificate 2015 was not given, you just supply the marks.
2015 mark sheet was not given.
Mark sheet given, not the certificate. Therefore, Lordship will find categorical mentioning of certificates of TET 2011 or downloaded marks of 2015. Therefore, 2 years to different requirement.
But in the certificate of 2011, how they will find the marks?
It must have been mentioned in the certificate. Otherwise, why you will take a certificate? That could be.
Then downloaded mark sheets
Yes.
of TET.
Candidates will be allowed to apply under any one medium of instruction for the post of assistant teacher. But this medium of instruction, what I believe, is well understood. There are many mediums, Hindi, Urdu, Nepali, this and that. That remains. Then below the preparation of panel and other details are given. Vacancy position at page 19. They have declared below vacancy as on that date region wise, and then nota bene, detailed subject-wise vacancies are available in separate sheet in our official website. Final vacancies may increase due to creation of new vacancies, and vacancies may decrease due to general transfer on special ground and transfer in compliance with the order of the Honorable Courts. Therefore, the vacancy position was always tentative till you decide finally in terms of the rules. Number, I am not troubling my lord with this in detail any further, but I'm sure Mr. Sanyal has placed Justice Moushami Bhattacharya's judgment
Yes.
on what are the grounds the panel was set at naught. Now, my lord, I therefore do not place it and waste my lord's time. Kindly takes up now the affidavit filed by them during these proceedings. Justice Bhattacharya directed do it de novo from a particular stage, and while these proceedings were going on, there are affidavits by the state. I shall first take your lordship to the affidavit of SSC on 27th of March 2020.
Written notes have. Yes.
But I do not trouble my lord with the numbers. Numbers are not important. What is important is not the basic question of infirmities in compliance of rules. Kindly turn to page 5, paragraph 9.
Page no.
5 of the affidavit. But this affidavit is dated 27th of March 2023. Affirmed by one Mr. Amodesh Chandra Rao. But I believe that this has also been placed, but
yes,
may I take the interest in placing it for little more clarification as per more understanding. After completion of interview, that this sentence itself negates all transparency. Okay. Yes. After completion of interview, what is your authority under the law to do anything after completion of interview? What do you do after completion of interview? Of all eligible candidates, the commission took up the task to recheck various aspects of each of the aforesaid 14,052 candidates. Now, my lord was asking one very pertinent question. If they go on doing like this, where is the end of it? Because it is settled position that they cannot travel beyond the rules. If they do travel, there is a provision, my lord, this body should be superseded. My lord will appoint an expert body to complete the process from the stage of Rule 9.2. Because this body, it not be that there should be prayer always. These are the developments, my lord, which comes in, and the court also correctly records. If they go on doing like this, where is the end of it? The persons are waiting for recruitment, students are waiting for the teachers. Therefore, the court, that in its inherent power, may appoint an expert examining body. There are many, and complete the process so that nobody can come and complain. Otherwise, this sort of thing going on, I shall place it, my lord's judicial council will be shocked. After completion of the interviews of all eligible candidates,
no, this after completion of interview means after the personality test, this was done.
Yes, that is the final stage. That's the stage of preparation of the panel.
Yes.
Of all eligible candidates, the commission took up the task to recheck various aspects of each of the aforesaid 14,052 candidates. That if your lordship permits me, my lord, with great temerity, my lord, I am praying, my lord will definitely take judicial note of the fact of the state presently, my lord, in the education recruitment. Otherwise, my lord, there was no authority to take up the rechecking after interview. Why did you take it up? You must have found that after the interview, I do not find my persons who ought to be there. This is my hunch. I repeat, Lord. Because these facts were not before me, so I can plead. These facts are, my Lord, coming out during the proceedings in the affidavit, and division bench of this court not has held in other matters that if the court finds during the proceedings some materials, court will definitely be a constitutional court. Look into it, take cognizance of the fact, and pass necessary orders. The commission took up the task to recheck various aspects of each of the aforesaid 14,052 candidates. The said exercise included a complete re-evaluation and scrutiny, which the learned single judge categorically was pleased to set aside, saying you cannot do this, this is beyond your power. Therefore, they though say that we are really carrying out the process in terms of the order of the learned court, but they are in fact betraying that. Complete re-evaluation and scrutiny of all relevant documents, including the scanned copies of the original OMR. Now, may I make a very humble appeal to your Lordship, let the scanned copies of OMR be produced before the court. In other proceedings, it has been done. Scanned copies of OMR, very important document, which is being relied upon, and the candidates are raising questions. Of the original OMRs of the candidates, scanned copies of the original OMR as good as original. I take it, there's no problem to that. Who participated in, you're reopening everything. Now, if you can do it by an independent agency, why can't the Honorable Court appoint an independent agency for the purpose of completing the process? However, the OMR sheets relating to TET 2011 were not scrutinized. As the said TET 2011 examination was concluded long back and all candidates have been issued their mark sheets and certificates, how can you make a differentiation between two groups now after having permitted them to apply in terms of the advertisement and the rules? Your convenience cannot permit you to depart from the rules. And this was also set aside by the Honorable Single Judge in her judgment. The OMR sheets dated in TET 2011 were not scrutinized as the said 2011 examination was concluded long back, and all candidates have been issued their mark sheets and certificates. After the evaluation of the said OMR sheets of TET 2015, it appeared that there are 3 missing OMRs which could not be freshly evaluated. My Lord will not take me amiss if I say, why don't you re-evaluate all the candidates of 2015? It might also appear that many candidates who are not in a position to approach the court might have got the benefit. This selective approach is in total violation of Article 14. After re-evaluation, it appeared that there are 3 missing OMRs which could not be freshly evaluated. Further, certain irregularities were detected with regard to the OMRs of 1463 candidates. What are the irregularities? Who is responsible? Who went out of the zone of consideration? The irregularities included caste category mismatch for 2 candidates, mismatch of marks in case of 559, huge number of the 1463 OMR sheets, and defaced OMRs case of 902, along with the mismatch for which 1463 candidates have been treated as ineligible. If after interview you declare 1463 ineligible, it opens everything. Then you have to go back again from the stage of scrutiny and come up. You are scrutinizing the papers after the interview. And these are the affidavit of the SSC. After removal of said 1463 ineligible candidates, the total number of candidates who successfully appeared in the interview and are fit to be included in the final merit list, panel plus waiting list is 12,589. The final result of the re-evaluation reveals that only 1259 candidates are now eligible. This is not only manipulation, I would again, with great bit of caution say, here comes the corrupt practice into operation for the reasons which might be disclosed of proper investigation. Then kindly come to the next paragraph. তুমিও করতে পারো তুমিও করতে পারো কোনো আপত্তি নেই তুমিও করো তুমি করতে পারো কোনো আপত্তি নেই সৎভাবে করলেই হয় then kindly come to paragraph 10 it is pertinent to mention it is pertinent to mention paragraph 10 that in the instant selection process for upper primary teachers there are a total number of 369 different merit panels that reflects the category wise panel. Quite appreciated. After taking into consideration the different subjects, medium of instruction, caste category, and higher gender category, for the purpose of preparation of the said merit list, candidates are called for personality test in their respective categories, which an interview list is prepared in the ratio of 1:1.4 of the final vacancies. In some of the categories, it often happens that the ratio is not made for want of eligible candidates. More than 2 lakhs of candidates participated. And while shortlisting, you have manipulated. Now you say that there is want of eligible candidates. When in some of the categories, the ratio is exceeded as well candidates who got the same marks as the last candidates. Not important. However, as already stated, there are 1463 candidates whose candidature after interview percentage were cancelled as on rechecking and mismatch. But if further rechecking and mismatch done, hypothetically, another 5,000 candidates may appear. So what is the sanctity? And what is the conclusiveness of the proceedings? Then the commission may call for required number of candidates. Not, I am not troubling my lot with that. Therefore, this is the affidavit by School Service Commission first on 27th of March. Now kindly takes up the affidavit on 24th of April 23 by the same gentleman. Affidavit.
Yes.
I am told, my lord is looking at the compilation, that will be of 20th April.
Yes, yes.
Yes. Now, my lord, may I read, my lord, very important. The paragraph 3.
Page 37.
Paragraph 3. Paragraph 3.
In paragraph 9.
In paragraph 9 of the said affidavit, which he refers to the earlier paragraph, it had also been stated that on further rechecking of the credentials of the candidates, irregularities were detected with regard to the AMRs of 1463 candidates. The irregularities included caste category mismatch for 2 candidates, mismatch of marks of 59 candidates, and defaced OMR sheets, as well as mismatch of marks in respect of 902 candidates. In the said paragraph, it has also been pointed out that the total size of the merit list and waitlist list was 12,589. I say that after affirming the said affidavit, the commission took up the task to analyze and recheck the defaced OMR sheets of 902 candidates more minutely. I am tempted to make certain comments, but I am restraining myself. These are the responsible persons. Go on checking, rechecking, go on checking, rechecking until you find out your list. On rechecking, it was found that the defacement of white mark, very serious, kindly note this. The advertisement says that the candidate must use black pen to fill in the bubble. Now they take out the white mark. There are allegations that some persons were appointed with blank OMR sheets. This is one of such instances might be. Blank mark. I say that after affirming the said affidavit, the commission took up this task to analyze and recheck the defaced OMR sheets of 902 candidates. On rechecking, it was found that the defacement, a white mark, was mostly put in spaces provided in the OMR sheet for bubbling the chosen option. That as A or B or C or D in response to a particular question. Now, in case of a question where one of the options has been covered by a white mark and none of the other options have been shaded by the candidates, the presumption may be drawn that the candidate has marked the option which has been covered by the white mark. But if I am permitted to say, this was the instruction given. Find out the white marks OMR sheets to suit my objective. And this is the clear admission. On presumption, in case of a question where one of the options has been covered by a white mark and none of the other options have been shaded by the candidates, the presumption may be drawn that the candidate has marked the option which has been covered by the white mark, and he may be awarded marks accordingly, as it is not expected that a candidate would leave any answer unattempted when there is no negative marking. The Commission took up the task of re-evaluating such OMRs once again and checked whether such candidates would benefit if marks are awarded to them on the presumption that they had indeed chosen the option that the computer could not recognize due to defacement. But if this is the statement of the Civil Service Commission, where do we stand? Can we say that this person, he is rightly chosen? Nobody can say. And Milord, I just give your lordship, Milord, one instance of OMR sheets, Milord, how it is to be marked. Milord, I just hand out to your lordship. The indication on the OMR sheet is Shudumatro Kalo Nilkalir Boy Employment Babhar Korben. Lordship must be well aware, but still, Milord. This is the Milord one OMR sheet. And the instruction given, Milord, at the bottom. These are all blank OMR sheets. And blank OMR sheet, Lord, the marks are given in the competitive examination on presumption.
It was not blank, it was marked and thereafter the white dot was put upon it. That is their statement.
That is the statement, but I feel that's a blank. Therefore, when you are checking or rechecking, you find this is white marked. Who had marked it after the OMR sheets were deposited?
White mark line or white mark. Who will the white?
Then
what is a defaced OMR sheet, Mr. Water?
Well, I really can't follow. Defaced means that means that it can't be said that the OMR sheet is totally
own condition.
Totally is blank. Or like the red marking are there, that is also changed. That is defaced. What could be defaced? That's why I am praying, Milord, Lord, you can direct the production of OMR sheets. But we have to bring it, Milord, at some point of time, thus far and no further. Otherwise, Milord, as my Lord was apprehending rightly so, how long it will continue? It continues if these things are not stopped with very strong hand. I say that upon rechecking the said defaced OMR sheets in accordance with the aforesaid presumption, that the person who was forced to affirm this affidavit was a very intelligent person. That's why he always went on insisting upon presumption.
Yes.
It appears out of the said 902 candidates, there are 81 candidates who still had mismatch of marks on comparing the marks of the rechecked OMRs with the marks in server of the commission. Now the question comes from the server. Then kindly come to paragraph 8. In view of the changes in figures as stated above, the total number of candidates called for personality test vis-a-vis the final vacancies now stands slightly altered.
Yes.
Then paragraph 9, in view of the above, it is most respectfully stated, after further reassessment, And rechecking of the defaced OMR sheets and rechecking of the academic score of the commission is now ready to place the final merit list before the Honorable Division Bench. Still then they were not ready. And these are all minute statements made derived from records. Number, I don't want to trouble this division bench without citing so-called authorities. This is basic principle of law. Basic principle of law is when there are statutory rules, you have to strictly follow it. I don't have to cite any authority on that. And your admission on affidavit is that you have used your presumption to give marks after the final interview list was prepared, and checking not once, checking, rechecking, reassessment, further checking. Now, but this being totally corrupt procedure, the entire thing has been corrupted, my lord. My lord will be pleased to set us, do not permit them to continue further, and let it be done afresh, my lord. I repeat, by a body, my lord, who can discharge duties truthfully in terms of the order of the court. So these are my humble submissions. Reservation বলা হয়েছে। Reservation নিয়ে সুবীর বহু
So this they could have done even. What they have done is after interview they have collected defaced. This they could have done prior to the preparation of the interview.
That was the basic duty. That means till then he was satisfied with all the statutory marks, state weightage, everything. Now, how can you go on inviting the people on presumption and then say after interview I am checking? Thereby you are in fact, what should I say, cheating these examinees.
Yes.
My learned juniors have given certain examples. I do not want to burden my lord with the example.
You can give us the page numbers.
Yes, yes. That is law notes on behalf of the applicants. Can Nasreen Khatun.
Can 74.
Page number গুলো বলে দাও।
No, please give us that can number.
Can 74.
Lekho.
Can 74. Respondent number was supplied by my learned friend.
আস্তে আস্তে নাম্বার
আচ্ছা can 74
law
of
notes
2023.
2023.
Very good. Give the cost title. Cost title.
Rajiv Brahma, MAT 63.
Acha, can 74. Give the page numbers.
Respected.
All right, all those are added there. ওইটাকে একটু বের করবে।
Law note.
বের করে
page number গুলো দিয়ে দাও।
Yes.
May I
thank you.
give a copy of law notes?
আরে আছে
That is there.
দেয়নি ও আচ্ছা তো these are all submitted before the other bench না fresh দাও আমার নোট দিয়ে দেবেন
We will get it. If we don't get it, we will take from it. We will check up the records and get it.
I gave some examples. Non-tender sir একবার বলে দিন এই শুভঙ্কর।
All right.
Yes, I'll just 10 minutes to clarify tomorrow or now. Kindly with the law notes, I shall just give a short note for mentioning the page numbers of the instances.
Yes.
And non-trained, Milord, if the
No, Mr. Bhattacharya, we are concluding after Mr. Bandyopadhyay.
In reply, I
finishes. In reply, if
Yes.
you want to say something.
Non-trained will come
Appellants
after
ওই ব্রহ্ম and Mr. Bhattacharya, learned senior counsel, senior advocate, appearing for the appellants in you. Mr. Shamim, what is the appellant?
Can 74.
Can 7. Matt?
main appeal 20.
My MAT number 638. 638 of 2021. That is Rajiv Brahma.
And which Mr. Bhattacharya is appearing? Which
We will give a list, my lord. With several matters, my lord. We have
just tell the main appeal na in which Mr. Bhattacharya is appearing.
MAT number 638 of 2021, can number 74 of 2023.
Stroke can number 74 have concluded their arguments. Stop, Mr. Bandopadhyay, learned senior advocate, learned advocate.
29.
And
May
item number,
comments, learned senior advocate appearing for the commission may commence his arguments on, may commence his arguments. Mr. Bandopadhyay, learned senior advocate, may commence his arguments on behalf of the commission.
No.
You are for whom?
I am for the substitute person.
Candidates.
Selected candidates who are in the panel and the wait list.
Very good. And
Yes,
you will be.
But I'm being led by Mr. S.N. Mukherjee. He is not available right now. So then,
When is he coming? When he is coming?
my lord,
We are fixing it on Tuesday, 2 p.m., sir. We will finish it off. We will
very well. Let it be on Tuesday, 2 p.m. I will.
Monday, there is a problem as regards combined list. No, Mr.
Monday করবে কেন? Monday তে SSC matter হবে।
Monday SSC.
Monday.
বুঝতে পারেন করো, Wednesday করো।
Wednesday কি আছে?
Tuesday I have.
Look, I mean,
Mr.
this part
Dr.
that Mr. Jayant Mitra wants to not speak for some time.
No. Mr. Mitro told us that what Mr. Sannal is submitting, let him submit.
Hey, I am appearing.
So far as the addition of party applications, no, several appeals, please consult with Mr. Sannal. Yes. Same allegation. Listen, sir, we cannot indefinitely go on hearing persons. At the inception, we said that as Mr. Bhattacharya is leading you all.
এই তো মেইন ম্যাটার। এক মিনিট বললেন, হ্যাঁ
বলো না।
Thereafter they executed. My case is the 36. According to this one, the question order I included, subsequently thereafter not executed.
Yes, that is the argument.
Then we asked your junior, you
Give the note any point you have.
can such and such.
I have filed the compilation. Show me the circular. This is what I have got me.
All right, come on the next date.
But item 10, I am for the appellant, but that relates to the non-trained. If the trains are not available, then only non-trained would come. That's the point.
Then Dr. Patro, Mr. Mukherjee will be there.
My lord, that I will have to consult. Your lordships fix it. Your lordships fix it. I will talk to him.
No, if Mr. Mukherjee doesn't start, then I will argue, because we can't wait for an indefinite period. Now, either Dr. Partho argues.
Patro, please request Mr. Mukherjee.
Dr. Partho argues.
I was
completed.
Yes, I was
indefinitely. We do not want.
No, we also do not want it, but he will not be available till the 12th. Now, in between, whether he can come online, that is what I will discuss with him. Your lordships fix it as per your convenience.
We are fixing it on Tuesday.
Yes.
Tuesday at 2 p.m. he will come.
I will.
Now it is advocates' cooperation.
Yes, I will not ask for adjournment. Let all the other learned lawyers conclude. Then, when our turn comes, if he is not available, I will start.
You are the main person, sir.
Yes, I understand. I understand.
Tuesday, your lordship, Tuesday. Tuesday, I'm not very personal difficulties.
Wednesday.
The item 10 may be recorded.
Item 10.
I am the appellant for the non-trained. That situation will come, only trained candidates are not available. That's only the
No, that will have to be argued.
তাই তো বলছি আলাদা issue. Item 10, Milord, is the
Mr. Bhattacharya, after this start, if you think any point has gone unleft, you can give it us on that.
That is only with regard to untrained. That point is the untrained candidate also applied. There are cases if the trained candidates are not available, then they may give a given chance. That's all. That's the law. Yes.
So this synopsis you can give it to us by a chart also.
My lord.
Very good, very good. We are not shutting you down, sir. We will hear you.
We are
on
asking you
Wednesday.
prepare a list of your application, how you are necessary party or you can be added here. We are saying that
You have given us, you have not yet given us the chart of addition of party. Which one?
Of addition of party.
তো দিয়েছে নাকি? চার্ট দিয়েছে? Alright, we shall check it up, come on the next day, whatever. We don't know further applications can also come.
No, that will
Take
come.
it, huh?
That you lordship, that will continue. Until your lordship delivers judgment, that will continue. That you can't, lordship
This is
cannot
matter for,
cannot
that is
stop
why
it.
we will take everything all at one go.
It is there.
The cost title has become 60 pages, I think.
I
We
think,
are-
yes,
we are-
yes, yes. Yes, 60 days.
The Nasrin Khatun is the respondent number 2087.
Doctor, লিখে দাও Dr. Patro.
They will come.
Who? How many?
Dr. Patro.
Respondent number 2087.
কোথায়? তোর তো হবেই তো 2.5 লক্ষ লোক নিয়ে বসে আছিস তো। That is the only thing.
না, এর লিখে Dr. Patro, learned advocate, and Mr. Bandyopadhyay, learned senior advocate, make comments there. Make comments their arguments on behalf of the commission and the other respondents.
You, they said that is the applicant. Why he wants to be added party? Like he applied this
Matter for
or he participated in such and such.
last
In this way, we shall dispose of all the claim.
Cost title print out দিয়ে দিও সেরকম হলে হতো। বুঝেছো? ওই যে বুধবার কত তারিখ হচ্ছে? 6th as fixed at 2 p.m.
Mr. Bhattacharya, I have a very
Expect Mr. Bandyopadhyay, you people will complete it on that date.
Yes, I will, Lord,
Please make an
I will
endeavor
take
to
hardly 45 minutes to one, hardly.
Dr. Patro, request Mr. Mukherjee, or online it becomes very difficult. If he can
But
come,
I think he's out of station.
He's out.
then you are in station, you are in charge now.
And in trouble.
No, why? We didn't say
No.
you feel trouble before us.
No.
Nobody feels trouble.
Most comfortable.
My lord, pardon me, my lord. Mr. Bhattacharya is appearing in item number 9 and 29, my lord, kindly, and 27. I just.
No, Mr. Bhattacharya appearing for MAT 638.
MAT addition of party in MAT 638.
Numberটা দে না
Addition
লিখে।
of appearing for the
Addition of party in MAT 638, that is can
appearing for those can
74
appearing for the applicants in can 74
4 of 2023 in Nasrin
in
Khatun,
connection with MAT
638 of 2021 in Rajiv Brahmo, and item number 29, that
And
is
for
Choton
the-
Saha,
and for the appellants in MAT number.
mat number 655 of 2021 Choton Saha.
Arey, why you are going on? Why you are?
দিয়ে দে না লিখে দে না।
I will give
No, this much will remain.
no,
You know, we are only.
These matters were not moved. Only the part which has been moved, let that be recorded in the.
Yes.